And welcome back. Hopefully your week was amazing. We're going to close it out strong here today from our final broadcast from this studio. Happy to be here with you. We have some good updates today. A judge is saying that the Maricopa County Board of Supervisors in our state is up to no good, engaging in some election shenanigans to try to jeopardize, is the language, the integrity of the proceedings in the battle between the Board of Supervisors and the Arizona Maricopa County Recorder called Justin Heap. And we've got midterms coming up, primary season upon us. We're trying to figure out where are the polling places and who's in charge of what, and how will our rigged elections in our state be conducted, hopefully with integrity. So we'll debrief that. We got some great clips on this as well. We'll look at the decision from the Superior Court of Arizona and see what the judge had to say specifically about it. Use the words shenanigans. Then we'll get into Missouri. There was a redistricting order that came down and said that the challenge to try to cancel the Missouri redistricting, which is giving Republicans an extra seat, is now denied. They're not going to win that one. And the current map will stay in place, which is good news for the Republican Party. So we'll see what that looks like. Go through that decision. And then a little Friday fun. We have a 98-year-old judge. You may have heard this story. She has been suspended. She's a federal judge. She's appointed. We know that you are appointed for your entire life. And sometimes judges die. Sometimes they retire. But sometimes they just get old. And she was now suspended. The head judge, the chief judge, said, we don't think you're doing a good job. And they suspended her, stopped her from being able to manage her caseload. And now she's taking it all the way up to the Supreme Court. And I've got some clips of this lady, and it's pretty amazing. She's 98. She looks pretty damn good, I'll say. So we'll go through that and see what you have to say about it. It's a lovely Friday. I hope you have accomplished every single thing you set your mind to. And we appreciate you joining us early on the stream. The reason we're early here is we've got an ultrasound this afternoon, the big one, the 20-week ultrasound. So we're going to be doing that all afternoon. We got like back-to-back appointments. And then we're packing this puppy up. Membos, we'll be back tomorrow, Saturday, and we'll do a little stream. We're going to test our mobile setup and say goodbye on the Saturday show, but then we'll come back and we'll be back into the somewhat of a schedule next week as we are traveling out to Washington, D.C. to hang out there for 18 months is the term of our lease. So we're going to go check it out and see what we can do to save America in Washington, D.C. But thanks for being here. Thanks for subscribing and all of the things. It looks like the tubes are working appropriately, which is great news. That means we can go ahead and get started right now. Victory in Arizona. A judge saying that the Board of Supervisors is trying to engage in election lawsuit shenanigans, and he's not happy about it. Of course, we've been talking about this for a while, and one of the law firms that is on the side of Justin Heap, the new Maricopa County Recorder, whom Charlie Kirk was a big fan of, says that they are celebrating, saying the Maricopa County Superior Court denied Maricopa County, the Board of Supervisor, and we'll do a recap on this to explain kind of how these moving parts work. But we have different people responsible for different components of our elections here. And there's a power struggle. Who does what? And on the way out, our last county recorder, a guy that we're not a fan of called Stephen Richer, you may know him. He, of course, is an anti-Trumper. He was part of nonprofits or some organizations that were very anti-Trump. And on his way out, he entered into a services agreement between the two parties. So he's in the county recorder position. We have the Board of Supervisors position. And as Richer was leaving, he basically divested himself, or the office rather, of certain powers and gave it back over to the Maricopa County Board so that they could continue to do a terrible job with our elections that nobody trusts at all. So that, of course, is a problem for the incoming county recorder called Justin Heap. He's saying, wait a minute, these are my powers. You can't strip me of these things. That's illegal. And so there's been a lawsuit, lots of lawsuits actually back and forth all across Arizona. America First Legal, we know who they are. They've been doing great work on a lot of different right-aligned causes. We're happy to see that the right is building its own legal institutions to combat some of the leftist institutions. But they say there was a last-ditch effort to delay a decision in our elections lawsuit. Now, the court said they're not going to be rewarding such shenanigans or allow this gamesmanship to interfere with or jeopardize the integrity of these proceedings. And we'll take a look at the decision, but here was a little bit of a recap. Fox News put together this short clip, and we were here. We covered the entire hearing live between the board and Justin Heap. It was insane. They were demanding he come in and testify under subpoena. And if he didn't show up, they were going to try to remove him and then install somebody else. And of course, continue on with their thievery. But Justin showed up. They're like, you have 10 minutes to explain yourself. Didn't ask him anything substantive. Then as soon as he left the room, they then started ranting and raving like lunatics. Like, why is Justin doing this? And how come he didn't answer this? And they had their lawyer. They were talking amongst themselves. It was like a cup of, like a tea party or something. And they were abusing him when he wasn't even in the room. And we were thinking, he was just there like 5 minutes ago. You could have asked him all of these questions, but they didn't want to do it because it's just a full-blown hatchet job from our so-called elected officials. But Fox News, a little bit of a recap. This is from a couple weeks ago, just to kind of wet the whistle, as they say, so that we can see what we're about to get into in case you missed when we were here covering it live.
Struggle between the Maricopa County Board of Supervisors and County Recorder Justin Heap continued at a special meeting today.
Heap giving sworn testimony today on election-related concerns, including claims of voter disenfranchisement. Fox 10's Nicole Christine was at the meeting and joins us live with what happened there. Nicole.
Yeah, good evening, Christina and Mark. So when the Board of Supervisors voted recently to compel Recorder Heap to testify, they cited an Arizona statute that could give them the authority to remove him from his position if he refused. But Heap did show up, he did testify, and so that is no longer in question. What is what comes next in this legal back and forth.
Are we disenfranchising voters now, as your chief of staff said in court under sworn oath, or are we not?
The question of voter disenfranchisement, one of many asked by the Maricopa County Board of Supervisors Wednesday during a special meeting during which County Recorder Justin Heap gave sworn testimony regarding election-related practices and resources.
No one likes them.
Supervisor Debbie Lesko questioned a statement made by one of Heap's staff members in a recent meeting.
I think what he meant to say was that it had happened in the past, and we're making sure that doesn't happen. I certainly have spoken to my staff. We have not seen any evidence that so far this year that this lack of an Judicial machine has caused any
problem. So, of course, that is what we saw. Oh, that's Joe Rogan playing. Thank you, Joe. We love you. Here's one from another clip. So, AZ Suburbs, we were here watching this. You could see the people booing the Board of Supervisors. And this was then the other angle of this, where this is Justin Heap, and he was communicating with Kate Brophy-McGee, and you could hear the crowd very unhappy with what the Board of Supervisors is doing and how they're trying to kind of steal this power away from this guy who's elected, who was elected to come and fix our elections, and they're trying to prevent him from doing that. So here's this short clip.
I am working to establish enough of a relationship on behalf of the board so that your testimony...
Stop it! No. Okay, so that's how it went, that whole hearing. It was a lot of fun, and the crowd was not having it. All these Board of Supervisors all saying, elections are perfect, Justin. Stop your reforms. We're not going to give you the power back. And they subpoenaed him. Then he was there. Then they threw him out of the room. And then they spent the next 45, maybe longer than that, just shredding him with their lawyer. They brought their lawyer in to say, why is Justin Heap so bad? He's like, well, here's why Justin Heap is so bad. And all of them then voted, and now the lawsuit continues on. So we saw that, and we got America First Legal. They filed this lawsuit back in August 2025, saying 2 bombshell legal motions on behalf of Justin Heap, exposing breathtaking abuse of power by entrenched government officials that are trying to sabotage election integrity efforts. The motions in Maricopa County reveal how the Board of Supervisors and County Attorney Rachel Mitchell in Maricopa have weaponized the county government against the elected recorder, Justin Heap. Why? Because the law says that he has certain powers that they're trying to alleviate him of. The legal filings expose the shocking details. The Board of Supervisors have now launched what appears to be a sabotage campaign. Just before Justin Heap came into office, the board seized control of the recorder's office of servers, databases, website essentials, basically saying he can't do his job. The board also removed nearly all election IT staff from the recorder's office, leaving him unable to perform basic election duties. Then they failed to fulfill their half. In Arizona is kind of weird because we split these duties up. The county recorder has certain responsibilities. The Board of Supervisors has others. Despite Recorder Heap's attempts to have resolutions and to negotiate, The board refused to negotiate. And so they started suing each other, and it's been just a battle back and forth. And the latest update that came in earlier this week was from the Board of Supervisors. They submitted this 105-page motion, and they're super mad about this. They said, Judge, Recorder Heap lied. He came in, he testified, he built his case on false testimony, the subject of which was not timely, and it's false evidence, and the board wants this. And we think that you should impose, they passed a resolution, right? Ultimately, at the end of that conclusion, they passed a resolution. They said, this is how we're doing things. We voted, and Justin, eat it. And you're going to have to do what we say. And he's going, what the hell? I have my own powers. The literal laws that the legislature passed give me certain powers, and my predecessor can't contract those away to you guys, essentially, on his way out, so that my office is undermined. In other words, the incoming county recorder has less power, less authority, less capability than the prior county recorder. Says this is ridiculous. So they say, we passed this unanimous resolution. They threw him out, they passed it, and they say, this is what you have to do. And Justin Heap said, no, wait a minute, I'm not doing this. He says it might be invalid under open meeting laws, and he made a bunch of arguments about it. But what happened, of course, is this was a filing from the Board of Supervisors up to the judge. The judge, they want to basically rubber stamp this thing and say, yeah, your unanimous resolution is perfectly acceptable. You guys do whatever the hell you want. Unfortunately for them, we saw this decision come down yesterday, and it's a fun one. You can see Justin Heap versus Thomas Galvin, and the judge is not having any of it. Here's what he said. All right. I reviewed your motion here, Board of Supervisors, your request for relief, and I responded, and I read the response. Now, this is a special action. There's been an ongoing dispute between County Recorder Heap and the Maricopa County Board of Supervisors. The court held an initial status conference near the time of the filing. So some time ago, once this all got started, we had a conference, a status conference to figure out what the heck's going on. Then the parties subsequently proposed a briefing schedule. We had cross motions for summary judgment, and we even held an evidentiary hearing to resolve any factual disputes and to serve as a trial on the merits. Okay, so we've already litigated a lot of this, says the judge. Now, pursuant to that schedule, we had a bunch of motions back on August 11th, August 12th. We had responses September 2nd. The court then held an evidentiary hearing back in January, not long ago, January 26th. Both parties appeared for the hearing. They presented their evidence in the form of documents, witness testimony, and they cross-examined each other, okay? We had a hearing. Sounds like it went terribly for the board. Almost immediately after that evidentiary hearing, okay, the board says we're screwed. So the Board of Supervisors then fired off subpoenas to the recorder and to witnesses that had appeared on behalf of the recorder at the hearing. So we're in a court proceeding. The judge says, I'm running this case, okay? I've got cross motions, briefings, summary judgments, deadlines, evidentiary hearings. It's all happening. And I'm the judge. So then as soon as that was over, the board says, no, you're not. We're the judge. So they fire off subpoenas to him and to the other witnesses. The board issued its subpoenas, not through the judge. So we're litigating and well, we're going to try a parallel track here. Pursuant to its own statutory fact-finding authority. They say, well, other law says that we can just do this, which is what we covered. The subpoenas were not for testimony before this court, says the judge, not happy. They instead required witnesses to appear in front of the board under oath in front of a hostile party and not a neutral arbiter. And without the protection of the rules of evidence, right? It was a free-for-all circus, which is why we covered it. It's like, you're in the court, you're in a judge battling against somebody else, and then you don't like what's happening in the courtroom, so you just say, you know what I'm going to do? I'm going to hold my own hearing, and I'm going to subpoena the person I'm suing. And then I'm going to bring them in, and I'm going to have 4 of my friends and my lawyer just shred this dude under the color of law. It was insane. We were here melting down. Now, upon learning of the board's compelled extrajudicial discovery, the judge is saying, you did this outside of my courtroom. The court became concerned that the board had issued subpoenas in retaliation for the witness's testimony at my hearing, and further, that the board issued the extrajudicial subpoenas to improperly influence these proceedings. Oh, dang, son. Just like they're trying to improperly influence the elections. Oh, weird. Seems to be like there's a pattern emerging, isn't there? On Recorder Heap's motion, the court issued a temporary restraining order barring enforcement of the board's subpoenas until after the court received the proposed findings of fact and conclusions of law. The court is saying, I'm litigating this. We're here in court. The court specifically stated following the TRO, the temporary restraining order, the judge said this before, back on February 5th, said the court is concerned that such an action taken by an opposing party so close in time to this court's hearing, in other words, the Board of Supervisors being big babies and then dumping off a bunch of subpoenas after they had a bad court hearing, focused directly upon the testimony of witnesses who appeared before this court. Like, we already got their testimony. They already testified. You don't need to haul them in again. Calling it amounting to retaliation and interference in these proceedings. Wow. This court has a duty to protect the integrity of these proceedings and the witnesses that appear before it. That's what we call a legal backhand to the Maricopa County Board of Supervisors. Stop trying to proceed extrajudicially. You're in court. The court has jurisdiction. You can't just change everything because you're unhappy with how this is going. After receiving the proposed findings of facts and the conclusions of law, the court then dissolved the TRO. The board now seeks to use the recorder's compelled extrajudicial testimony outside of court to discredit the in-court testimony of the recorder and his witnesses, as we just heard in that little clip. Oh, well, you went and your people said something over there, and now I'm going to haul you into my court, and I'm going to scream at you about that, and then try to sanction you or disqualify you or override you with our unanimous decision. But again, says the judge, the testimony on which the board now relies was taken in front of the board, in front of you, an adverse party, not this court, based upon questioning by a hostile adverse party without the protection of the rules of evidence, without a neutral arbiter, and without legal representation by Recorder Heap's attorney. So the board moves pursuant to the rule for further discovery now. Now you want to go in and open up all the records based on that testimony with the intent of subsequently submitting that testimony and any additional evidence back to this court. So you're using your outside proceedings to gather evidence. You guys are not neutral. You guys all pretend like you're on this board and you're all independent, whatever. You're all on the same team, obviously. And then you're going to go take that evidence that you use via your powers and then shove it back into the court proceeding. The judge is saying, this is my courtroom. You're not running this. So Rule 56, as the motion we just saw, permits a party to seek a delay in responding to an opposing motion for summary judgment when that party establishes it cannot present essential evidence to justify the motion for summary judgment. Now, whether this relief and whether to grant it is within the discretion of this court, not you, citing some case law that supports that. And so since it's my discretion, here's what the court finds. The court finds that the defendants, the Board of Supervisors, have not established good cause for their requested relief. This is not a proper use of the rule asserted for the first time after one. Both parties, you guys already agreed to a briefing schedule, and you agreed already to an evidentiary hearing. You've already had this. Both parties filed their respective motions for summary judgment. Both parties filed their responses. Both parties also appeared at the evidentiary hearing. You already presented evidence. You already cross-examined the other party's witnesses in front of a neutral judge. The court has already taken the matter under advisement, which means he's just going to, consider it, do his research, go back into chambers, and he's going to make a final determination on the merits. And they're trying to usurp that, right? They're trying to basically entrap Justin Heap. The time for discovery, you Board of Supervisors, has long passed. And this is particularly true, whereas here, the case comes before the court as a special action. Discovery, by the way, is not even routinely permitted in special actions, which are kind of like appeals in the middle of a litigation, and cites the rules for that. Now, the court further finds that the court's initial fear, he was concerned about this back in February, that the Board of Supervisors was using its extrajudicial subpoenas in part to influence these proceedings. Whoa. Was well-founded. My fear was well-founded. I was worried that you were going to do this, and you did it. And these are the same people who then turn around at us and lecture us about election conspiracies, and we've already investigated everything, and just shut up and let's move on. The court will not allow this gamesmanship to interfere with or jeopardize the integrity of my proceedings. even if your board request actually constituted a proper use of the rule, and by the way, it does not, their words, the court would still not reward such shenanigans by allowing this extra judicial, quote, evidence to taint the record in this case. The matter has already been taken under advisement for a final determination. I'm going to make the decision. Stop trying to do an end run around the court. On a failure to show good cause and in the court's discretion, it is ordered that your Board of Supervisor motion is hereby denied. The court will issue a decision on the merits in due course. And now get the hell out of my courtroom, you jerks. So nice decision here, 3-11 from the Superior Court of Maricopa County, and a big win for Justin Heap, America First Legal. Nice to see that development. And they're trying to do an end run around the court, which is weird because I thought that these people like followed the rules. You know, there are certain procedures you have to follow, like when you're doing elections and like when you're delegating power, but they don't care. Okay, they just do whatever the heck they want. So far, nobody's really slapped them down until today. No more shenanigans, Board of Supervisors. Give Justin Heap his power back. And we're continuing to monitor what's going on in Arizona. And our friend Kevin Moncla, you know Kevin Moncla from a lot of the Georgia analysis that we've covered here. He's an election investigator and a consultant. He respects the will of the people, doesn't actually care who wins, as long as we have free and legitimate elections that have integrity behind them. Unfortunately, we don't, which is why we see unqualified people winning elections, like our governor and our attorney general and our secretary of state and Joe Biden. So he wrote this, you know, looking back to Maricopa County's 2022 election, and we have a big one coming up this time. We got a governor race again and more. He said, here are just a couple of the problems that he's found as an election investigator. First, 2 separate ballot printing platforms, we remember this, suddenly failed on election day. Weird. Sending thousands of ballots to door number 3, the back door on election day. Now, those door 3 ballots, which was weird, kind of like a textbook random sample, you have some kind of algorithm or something that's up, problem, up, problem, up, problem, siphoning off 11% of the ballots. There was, the door number 3 had an 11% swing, rather, favoring the Democratic candidate for governor and the attorney general compared to all other ballots cast on election day. How come that happens? It's kind of weird. He says that's what some might call probable cause, which is a fair probability that there's evidence of a crime, which justifies search warrants. Yeah. Of course, there is no shortage. There's also a bunch of other problems in addition to door number 3. And we were there during this time covering all of this. We had major delays out the door. So you had voter suppression out the door. And then a certain portion of ballots went into the back door and had to have further processing. Weird. Of course, there's no shortage of other problems in Maricopa. Explaining, 1, they also broke the seals and they reprogrammed all of the election day tabulators with uncertified configuration files after logic and accuracy testing without notice. They did it behind closed doors. This happens all over the country. This was arguably happened in Georgia, and I would say definitely happened in Colorado when Jenna Griswold went and updated all the BIOS passwords. Once the machine is validated, you can't go in there and tinker with it and then expect the results to come out. You say, this machine is perfect. It's got all the config files. It has been sealed, signed, delivered. Run your stuff through it, and you test it in that configuration. Once you then certify it, it's good to go. We've done all of our testing. You put it into service. You can't change it unless you do the entire process, unless you pull it back out of service and then redo the logic and accuracy testing to validate that the changes you made are preserving the accuracy. That's the whole point. And this is a DUI analogy that we talk a lot about, but this happens with DUI machines all the time, gas chromatography machines. When you validate scientifically that this thing is going to spit out the right number, and then there's a tiny little problem. Software gave us this screen or burp or something's going on. You pull the whole machine out of service, you validate, you do a root cause analysis. What's the problem? Then you fix it. Then you put it back into service after it's been validated and tested again. Otherwise, every result that comes through that machine is going to be attacked by defense attorneys. I know I did that a lot. And that means that your DUI result is invalidated. If you just were a software company and you just said, well, I'm just going to like upload a patch on this thing and like just fix this. The city of Scottsdale, by the way, had a whole nightmare with this back in 2013. It was wild times. They were just going in there, like putting some duct tape on the side of the machine. It's giving us bad numbers. Put some duct tape on it. No worries. And then they took the results and they prosecuted people for those. And many of those cases got dismissed outright because you can't do that. And our election machines should at least have the same validity and accuracy as a DUI machine, because we want our elections to be valid beyond a reasonable doubt. The criminal standard, I think, is perfectly appropriate when we're talking about the people that are governing us. So that's a problem. They go in, the machines are broken, they break the seals, they adjust all the things to shove them back into service, and the Republican Party or even the Democratic Party can't validate that they're legitimate. Number two, they utilized tabulators that had actually failed that testing or were never tested in direct violation of Arizona law. Says if you don't test it, you can't use it because you can't be assured of the result. They also rescanned the ballots. You have to redo it on 41 election day vote centers that had been successfully cast on the precinct tabulator, saying if you can rescan ballots behind closed doors and then replace the results of the original scans, that's not an election at all. He says, I don't care what Stephen Richer or Katie Hobbs have to say about it. They're redoing the election behind closed doors. Nobody's validating it. Also, 4, they unlawfully utilized an election ballot duplication system called Novus in direct contravention of logic in Arizona law. An electronically populated ballot would be sent back to Runbeck to print it, which would have to be returned to MCTEC, which is the Maricopa County Tabulation Election Center, and then physically scanned. Essentially a wholesale ballot laundering operation that we can provably show cost Abe Amadei his rightful seat as the Attorney General. His election stolen from him as well. And we covered this earlier this week. Who was able to get video camera surveillance from Runbeck? Oh yeah, nobody. Because they said they're a third-party provider and they don't have cameras anyways. And the judge was like, well, they don't do anything important anyways. And in the future, they're going to provide a little room and some cameras that some people can go in to watch. But for the last elections, you can't see anything. All the ballots are being processed by some third-party provider off-site, and you can't see anything. They also staged a BS audit and investigation of the election day failures. Yes, it was BS. They used the BS results to needlessly replace printers at the cost of millions to us taxpayers in an effort to conceal the actual cause. Even one of the printer malfunctions in manufacturers called Oki had to call out County Attorney Rachel Mitchell in Maricopa for her bogus BS bonanza. Man, that's a great phrase right there. Performed a post-election hand count audit before the ballots had even been counted. You can see he clipped this article here for us that says hand count audit starts in Maricopa County. That's weird. November 12, 2022. Ballot count, though, continues 4 days after Election Day. So the whole thing was a mess. We had Harmeet Dhillon on earlier this week. She says, I was on the ground, by the way, during the last 2 election cycles in 2022 and 2024, and it was shambolic. It was a disaster. And they just tell you to shut up and just move on, will you? We're so tired of you conspiracy theorists complaining about elections. So what? Okay, move on. And of course, the grift is in the gray area. All of these little things, all of these little problems are openings for fraud. The reason why we have laws, the reason why we have logic and accuracy testing is so that we don't have the fraud. You follow the rules and it prevents that from happening, but they don't follow the rules. And then they just blame oversight, administrative error, or just their total incompetence. But here was Harmeet explaining.
Well, that's right. And, you know, I can't talk about the details of these matters. And I will say that my jurisdiction statutorily is civil in nature. And so my colleagues, after we've tried to go through the front door and get these materials voluntarily, if they're not complying to help them do their jobs correctly, then it may become criminal in nature, or at least certainly grand juries have agreed with the request for this information. And so, you know, we're going to look at them, and the FBI is doing their investigative work to see what they find, and then ultimately that may come back to some component of DOJ to bring charges or pursue that. But I can say as a lawyer who taking off my government hat and putting on my former political hat, I was on the ground in the last 2 election cycles in 2022 and 2024 in Arizona, in Maricopa County specifically. Yeah. And you don't know whether it's incompetence or deliberate malfeasance, but either way, it is a shambolic, bleep word show of a election process that leaves many citizens feeling like they shouldn't vote because they see the wrong paper being loaded. They see ballots being transported without proper security under state law. Yep. And then they see unclean voter rolls that are in violation of our federal election laws. And so we want every citizen to have the same outcome in the elections of our country as citizens in Iraq had when they vote.
Right.
You know?
Yeah, and let's talk about that paper, shall we? Because Lindell TV, Mike Lindell Offense Fund, they put together this little clip here for us, and they say this guy is called Walter Dougherty. He said Maricopa County stalled 5 months and then sent boxes, 1,600 plus boxes, where over 1,550 boxes had broken seals and 0 chain of custody. That's not messy. That's a ballot operation. And then, of course, all of the ballots, my understanding, are now nuked. You can't go look at the paper that they were actually printed on. And listen to this guy explain what that paper looked like, where it came from, and why it was so problematic.
Any problems discovered during the Maricopa audit. So in the first place, the Senate subpoenaed the ballots, and the Board of Supervisors delayed 5 months before they delivered the ballots. Out of 1,600 something boxes, all but about 50, the seals were missing or had been broken. There was no chain of custody on them. Dominion has a very specific requirement for ballot paper to be used in a Dominion scanner. So we're talking about something that's 4 or 5 times thicker than an ordinary sheet of paper. It has to be manufactured by the Roland Paper Company in Canada, and it has to have an infrared fluorescent watermark on it. Inside the scanner, there's an infrared light and a detector to make sure that the ballot that's been inserted is not counterfeit. But when the citizen auditors actually got to look at the ballots, they found 9 or 10 different kinds of paper, most of which came from Staples and Office Max.
Wow.
You say, well, how is this possible that they scanned 2 million ballots and didn't detect and reject the counterfeit paper? It's very simple. There's a configuration setting to turn the detector off. So basically, the machine was set not to check whether the paper being inserted was counterfeit paper. And you can count counterfeit ballots as many times as you want and get the same numbers. But that doesn't mean that they were legitimate ballots, because they weren't.
Paper from Office Max and Staples being shoved into the machines. And the configuration files adjusted so that they could not be caught. Very interesting. Then, when you try to go get your hands on those physical ballots, they say you can't have them. We're only required to hold on to them for so long, and they're all in the incinerator, so you can't really go look at them again. So that, of course, is a shocking clip from him, and I'm sure that there's going to be more on this from the FBI hopefully soon. But Mark Fincham was also out earlier this week with Lindell TV, and here is what he had to say. Mark Fincham is an Arizona state senator, and he is explaining that this is pure propaganda that they're trying to shove down our gullets to say elections are perfect. There's fraud everywhere. There's hospice fraud in LA. There's Leering Center fraud in Somalia, Minnesota. And there's, for some reason, no fraud that's allowed in elections. It just can't happen because we've got other guys like Stephen Richer in charge.
I don't want to preclude any opportunity for DOJ to make an announcement about what they're finding. But I happen to know some of the actors who have evidence that they have turned over. It's evidence that we were informed of back in November 2020. So for these clowns to say, oh, there's no evidence, Brnovich had no evidence. There was no evidence in court. Well, you did everything. This is the radical left Democrats. You did everything possible, including buying off judges, to keep these cases out of court so that evidence could not be presented. Well,
buying off judges.
There's a case in Atlanta, Georgia, curling. The curling case showed that these machines could indeed be hacked within 5 minutes from a damn cell phone. So don't give me this argument that we have no evidence. That is pure gaslighting BS coming from a media which, quite frankly, I am glad that there are shows like yours, young lady. I am glad that we have social media that now just goes around the artists of propaganda. We are engaged in fifth-generation warfare.
It's true.
And anybody wants to look up what that is, follow General Mike Flynn.
He's absolutely right about that. You can look at what's happening online with all the other things going on right now, and it is like a bloodbath out there. So, of course, we're grateful to Mark Fincham, a senator, state senator, who is continuing to focus on this. Arizona elections are coming up very soon, and currently the Republicans are looking like they're doing pretty well on this. Here was a report that just dropped 2 days ago that's a bit of a summary on what's coming up, and voter registration looks like it's turning out red at the moment.
Morning, everybody. Well, it's not a presidential election year. This is a huge election year for Arizona.
Big one.
Governor, Secretary of State, and Attorney General all up for grabs, including many other important races. And with the primary election on July 21st, all of us should get ready for the campaigning to really ramp into high gear very soon.
Buckle up, because it's going to start now. We're going to start seeing signs earlier than we've ever expected them. We're going to start seeing people with ads on the air and mailers in the mailbox.
Now, that's Paul Benz with High Ground Public Affairs in Phoenix. He says most campaigns will really start hitting their stride around Memorial Day, likely earlier than ever before because of that July date now. Now, back in 2022, Democrats won at the top of the ticket, taking governor, Secretary of State, Attorney General, and U.S. Senate. But this time around, who has the overall advantage in the state?
All
Republicans
Democrats.
or Democrats? Obviously depends on who you ask, and Benz is here to weigh in.
At this moment, with gas prices being above $4 and some of the financial challenges we're seeing in the wake of the latest international conflicts, certainly putting Republicans at a bit of a disadvantage going into the summer. That being said, Republicans have made up a pretty sizable registration advantage, compared to what we saw a few years ago.
So let's take a look at the numbers, and this is really interesting. These are the changes in voter registration numbers in our state from the last big statewide midterm election, November 2022, to now. Republicans, as you can see on your screen, have made some sizable gains with more than 110,000 new registered voters. Independents have also seen an uptick of about 80,000 voters, but Democrats, as you can see last on your screen, have lost ground. There is more than 50,000 fewer registered Democratic voters now compared to when Katie Hobbs was first elected governor nearly 3.5 years ago. So we will see if the voter registration numbers change at all as we approach the summer primary and our midterm election in November, but certainly something interesting and something worth noting. By the way, guys, just in case you were wondering, early voting in the primary starts in June, so buckle up. Certainly going to be a wild ride over the next 7 or 8 months.
Oh, yeah. All right, so numbers looking good for the red team, and you can see it right there. Democrats down 50,000, almost 51,000. Republicans up plus 113,000, which is probably why the Board of Supervisors and the current Democratic elected cabal like Katie Hobbs and Chris Mays and Adrian Fontes are all out there very nervous about what's happening, and lawsuits are flying. But as we saw in Maricopa County, the Board of Supervisors got the old proverbial legal backhand. Stop it. Stop trying to interfere with our judicial proceedings. We will not allow this gamesmanship to happen. We will not allow or reward these shenanigans. Finally, a judge is stopping them. But it begs the question, if they're willing to violate the judicial integrity and do things extrajudicially outside of this litigation, what else are they willing to violate? What else are they willing to do outside of the rules? We already know the answer to that. But fortunately, as Mark Fincham said, we've got some other eyeballs on this, and a lot of people are now wising up to their shenanigans. So we're going to keep our eye on this one, my friends. Thank you for subscribing and joining as we do. All right, now, that's Arizona. Let's go over to Missouri because we have a redistricting win over here. Victory in Missouri, a redistricting win now handed down by a local judge. You see the article here, written on March 12, says a judge rejects a challenge to their new map. And this is a big part of the midterm battle. Many states redistricting all over the place, and Missouri was one of them that did and is now under threat from the leftist lawsuits. But this is from a Jackson County Circuit judge. We had a 4-day bench trial back in February, and now we've got a decision. They asked the court to declare the 2025 map unconstitutional. They wanted the 2022 map put back in place, and this has been happening all over the place. They say, actually, your new maps are a little bit racist, and so a leftist group like one of Mark Elias's entities will sue, and then a judge will say, yeah, this is racist. You have to revert your map back. In fact, I think we're seeing that in Utah and some other places where certain judges are reversing what the legislature has changed because it is bad for their political party. Now, we'll go through the decision and see what the judge had to say ultimately, but it focused on a couple of districts and surrounding communities and urban neighborhoods and more. We'll read the decision, but here's a little bit of a brief from local news, KSHB, on what just went down.
Missouri's new congressional map will remain in place. Today, a Jackson County judge denied a request to block that new map. Back in September, the state legislature took part in a special session to change the map. The biggest changes are in districts 4 and 5. You can see that splits Kansas City into 3 different districts. Plaintiffs claim the state's constitution only allows redistricting once every 10 years. But Judge Adam Kane says the plaintiffs failed to meet a, quote, heavy burden that allows courts to intervene in political process.
Nice. So taking a look at those maps, you can see what is ultimately happening here. So in 2022, this looks like a very solid district in 5, which includes the big state, the big city. And then that has been broken up. So you've got 4, sort of the big cities are liberal monoliths. They vote blue in overwhelming numbers. And so that has been split essentially. So 6 now dips into that a little bit. 5 dips into that. We've got a bunch of rural voters who are being brought into 5. Same thing with 4. It looks like 4 also sneaks up in there. And we've got a new map that flips this 5 into a red seat. So from left to right. And the judge came down and said, legal, you can't challenge it. Says these cases were joined for trial and they became before the court for a bench trial back in February, mid-Feb. The trial concluded with closing arguments on the 20th. Plaintiffs in both cases request this court declare that the districting plan unconstitutional. They want to go back to the 2022 map and not use the 2025 map in the new midterms. Now, the judge says, let's go through this. Courts should not interfere with the political process by finding a map unconstitutional unless you meet a very heavy burden. Missouri law says you got to show something really significant before we're going to undo what the legislature changed. Supreme Court of this state succinctly said, these decisions are political in nature. They're left up to the political leaders, not to judges. And that's the general rule, right? The legislatures, the independent redistricting commissions, they're the entities that ultimately will create the maps. But under Missouri law, a plan enacted by the General Assembly is assumed to be constitutional unless it is a clear affront. And so guided by these standards and after careful consideration of the evidence, the court concludes that the plaintiffs failed to prove clearly, undoubtedly, that the plan was bad. Says the 2025 plan complies with the constitutional mandate that Missouri's districts are divided into contiguous territories with nearly equal populations. And this court is going to respect that. You don't like it, go vote for new local officials. We got more background. We got wise plaintiffs who now sued everybody on the state side. They said it's unconstitutional because they couldn't do it mid-decade. The same day they filed their petition, they filed a motion for an injunction and they wanted to stop that seat being flipped. September 28, 2025, the plaintiffs filed another petition seeking an injunction. Other plaintiffs came in. They alleged 2 other claims. Then the circuit court concluded that no, the General Assembly, the legislature, has authority to do this. It's going up on another matter into the Supreme Court of Missouri. Then on January 7th this year, another intervener filed. They said, we don't like this judge. So they wanted to boot the judge. Somebody came in, said, how about a change of judge and move it to somebody else? Then we held a bench trial. Before opening statements, counsel for plaintiffs and the state defendants orally requested findings of facts. And the judge says the court really didn't do that, instead views the request as one for a statement of grounds for its decision. But nonetheless, the court made some findings of facts. Here's what they are. Both sides' experts relied on the REOC measure, which is one of the first statistical measures of compactness that was invented. The REOC measure compares the area of the district to the area of the smallest circle that wholly encompasses the district, also known as a minimum bounding circle. So almost like when you make a cookie and you have a cookie cutter, you just take that big circle cookie and pop it right in there on the map. Both sides' experts also relied on this other measure called the Polsby-Popper measure, which calculates the percentage of a circle within the same perimeter and more. Now, even the plaintiffs acknowledge that courts have relied on these things for decades, and they come up frequently. And both sides agreed that this plan is actually more compact than the other one. And so they go through a lot of this technical stuff. They say District 6 is even more compact, it's even better. Even the 3 district plaintiffs and their challenge are more compact in the new plan than the old plan. So based on even the analysis and these other sort of methodologies, the new plan is better than the old plan. They have a Schwartzberg compactness measure and a Schwartzberg score and an Ikiwisi measure and an Ikiwisi score. And they're all great. The court finds that the quantitative data persuasively shows the new map performs better statewide than the old map. And the 2025 plan is not an outlier either. It's within historical measures of compactness, and it is valid. So 4 counties, he goes lots of details on all the splits and what the district line over Troost Avenue from Kansas City goes over to the Kansas City map. And they say that despite the notable history of this as a dividing line, they're not saying that this is racially discriminating. Okay, not. And that's been an argument in many of these other redistricting fights. I think the one I'm thinking of is Utah with Judge Diane Gibson, I think. Plaintiffs presented testimony from experts and several community members. The witnesses conceded that they did not speak to any Missouri legislator or map drawer about this. They testified about their preference for a map that would place urban districts in a single community. The plaintiff's expert also said they should have a single one and wanted the map to favor this urban location. They brought in some witnesses. Dr. Cromartie and other witnesses came in to testify. Lots of testimony happened over 3 days, fast forwarding through a lot of this. And we'll get to the conclusion of the court. And this is interesting. They put on no evidence about certain claims. No witness testified that this plan is not contiguous. Says no witness testified the plan does not create districts with equal population. They do. No witness said that there was anything double assigned. The only evidence at trial showed that these are assigned 2 separate districts, and they're named accordingly. And so here are the grounds for our decision. Now, under Missouri law, the plan is assumed to be constitutional. Any doubts about the constitutionality must be resolved in favor of the constitutionality of the statute. And their arguments throughout their attack on the plan is that rural voters are far flung from the urban centers. But that's not how this works. The 2012 plan was very similar. The result of their position in this case would be to make value judgments that, like, these rural voters on this east side of the state are too different from the urban voters on the west side of the state. But that's a values judgment. It doesn't comply with population or with the circles or anything. Constitution says if there's a doubt about it, we hold in favor of the statute. And the legislature passed this. We went through the constitutional test of compactness, and in order for them to reverse this, they must prove that the plan deviates from the other norms. Redistricting experts, including theirs, validated that some of these measures and methodologies are appropriate. Their experts, Dr. Service, Rodden, and others, went through it. The REOC, the Polsby-Popper, and they say it's actually better. The 2025 plan is more compact statewide than the 2012 plan. And so the court's findings establish that it's not unusual and finds comparison to prior maps even useful as well. So lots of technical stuff going on here. We'll fast forward through a lot of it. Various expert witnesses said certain things. The alternative maps that they proposed don't prove that this new map is unconstitutional. And even many of the experts agreed. Mathematically, there is virtually no limit to the creation of alternative maps that could increase the compactness. There's no requirement to maximize compactness, but in any event, they do not seek the alternative maps as a remedy. They want the old map shoved back in place. They focus on District 5, and they're not going to win. In conclusion, count 1 of each case remains stayed pending the Supreme Court. Their request for relief as to count 2 is denied. Judgment is entered for the government in Missouri on all counts. The request for other relief as to other counts is also denied. And pursuant to the Supreme Court rule, there's no reason for delay. This judgment is final, and now you can appeal it. I'm sure they will. And so the parties can bear their own costs on this case, but a nice win out of Missouri. So that seat should flip over. Here's another little bit more detailed news report on what they're saying out of Kansas City.
New tonight, a Jackson County judge has ruled Missouri's congressional district maps, which were redrawn last year, are constitutional.
Yeah, it was passed by Republicans and could help the party win an additional seat in Congress in November's midterm elections. Fox 4's Lexi French is live outside the Jackson County Courthouse tonight. Now, Lexi, what does today's ruling mean for people who live in the KC Metro?
Well, Scott, the Jackson County judge denied the claim that Missouri's state constitution requires that districts be compact. Now, the redrawn map in Missouri targets the 5th congressional district in Missouri, and that's currently held by Democrat U.S. Representative Emanuel Cleaver. It splits portions of Kansas City into 2 neighboring districts represented by Republicans and puts the rest of the 5th district eastward into rural areas.
We challenged these new non-compact districts and presented a host of different kinds of evidence at trial. Unfortunately, in the ruling today, the court overlooked a lot of that evidence and largely deferred to the legislature's choices.
The redrawn congressional map upheld by a Jackson County judge on Thursday moves the area west of 71 Highway in the KC Metro into Congressional District 4, currently represented by Republican Mark Alford.
Look, as we gear up, this is going to be a change for Kansas City. The old 5th will not exist. There'll be a new 4th and a new 5th. There'll be a new voice here in Kansas City, and hopefully that will be me. And I'm going to do the best job I can for every individual.
Missouri's congressional map still faces other legal challenges.
When politicians redraw the lines for political gain instead of having the voters' best interests at heart. So that's why we brought this case in the first place, and that's why we're going to continue advocating for Missouri voters and for a fair map.
The state Supreme Court is considering a case that argues mid-decade redistricting is unconstitutional.
Does the state legislature and the governor have the authority outside of the census every 10 years to redraw maps? And I clearly think they do. And lastly, according to the U.S. Constitution, it's up to the state legislatures to decide the time, place, and manner of elections. And this has to do with that.
We haven't received a comment from U.S. Representative Cleaver about today's ruling so far today, but we have reached out for a comment about this. We do have reaction from Kansas City Mayor Quentin Lucas, Missouri's Attorney General, and several other state and local leaders about the ruling. You can find those on our website, fox4kc.com.
All right, so big changes happening there. And the Republicans have their work cut out for them because Virginia just ripped off another 5 seats, I believe it was. And we've got other judges who are not honoring the decisions of the legislature. They're just relying on things like, this is racist, and then they're imposing their will on the voters over the duly elected officials who are obviously not judges. Judges are not elected. These people are appointed. Some judges are elected, but the judges overriding the legislature, which is really the voice of the people. And of course, we're going to keep our eye on this one, but a nice decision. I would fully expect that Adam Kane, the circuit judge's decision, will be appealed, and we'll have a battle that continues on as the midterms heat up. Thank you for joining us as we keep our eye on all this election litigation and more. We'll see you on the next one. All right, we're not done yet. We have a fun little decision and, well, a fun little case right here with this senior judge right here. Let me see if I can get a good place to start this right here. Right here. 98-year-old senior judge now filing at the Supreme Court saying, you cannot suspend me. I'm perfectly capable of managing my caseload, writing decisions and handling the job. But what has happened is she has been suspended. The chief judge in her district said, "We don't really like you anymore. You're too old. Get out of here, Granny." And she says, "I'm not going anywhere." So she's now being represented by this company or this law firm called New Civil Liberties Alliance. And they put together this little video here for us that we can watch together before we look at the appeal to the Supreme Court of the United States. We'll hit the highlights on this thing and see what are the limits on judges' tenure. We know that appointments are for the lifetime of the judge. And yes, you can be the judge up until the day you die. Look at Ruth Bader Ginsburg, for one who was in that position recently. People were encouraging her to retire and resign, and she didn't go anywhere. And neither is this woman. Her name is Pauline Newman, and she's been around for a long time. She was born 1927, and she is currently the circuit judge for the United States Court of Appeals for the Federal Circuit. As of 25, she's currently the longest serving active federal judge. But in 2023, she got suspended due to her concerns about productivity, cognitive decline. She disputes it all. And so we'll watch this video and you can see what you think. Do you think she's cognitively declined? Our senior citizens out there? Here is from New Civil Liberties Alliance before we take a look at what SCOTUS has to say.
The Constitution says federal judges serve for life, removable only if Congress impeaches them. Can federal judges bypass impeachment and remove a fellow federal judge from the bench?
That question is now before the U.S. Supreme Court. The judge is Pauline Newman of the U.S. Court of Appeals for the Federal Circuit. She's a legendary figure. She's an intellectual leader. She's famous for her independent-minded dissents, even nicknamed the Great Dissenter.
I thought that it was ridiculous and that I should not succumb or set a pattern of judicial colleagues being able to bully and intimidate and force out a colleague they don't like who writes dissents.
But the chief judge of her court claimed Judge Newman may be mentally or physically disabled.
So I refused.
Even at the same time, Judge Newman was writing excellent opinions.
These included one dissent the Supreme Court itself later approved over the opinions of Judge Newman's colleagues.
But the chief judge and her colleagues suspended Judge Newman. They demanded that she see a doctor they chose, even though she had been examined by 3 independent doctors, and every one cleared her to continue judging.
Interesting.
By now, Judge Newman has been suspended for 3 years, longer than any federal judge in U.S. history. The problem here is that the law has blocked Judge Newman from taking her case to an actual court. The Court of Appeals held her colleagues' actions are unreviewable because they were acting only to administer the court's operations, not to impeach Judge Newman.
So now, Judge Newman asks the Supreme Court to hold that she can bring her case to a lower court and get it to reverse her colleagues' effort to oust her. That ruling would end her unconstitutional suspension.
The New Civil Liberties Alliance has fought this battle for years because letting judges oust their colleagues without impeachment strikes at judicial independence and the rule of law itself.
All right, so she seemed pretty capable right there to us, but let's take a look at her argument to the Supreme Court of the United States. You can see Pauline Newman has sued the chief judge of the United States Court of Appeals, little judge versus judge action here, Kimberly Moore, in her official position for suspending the 98-year-old Pauline. Here's more. They say, the Disability Act authorizes each circuit's judicial council, after investigation, to order that on a temporary basis in time, no further cases go to a judge. Okay, judge is a little bit off, okay, you're done. Disability Act says we're going to pull your caseload. You can still be a judge. We're not taking you out of your role, but you can handle the cases. The act allows these orders to be reviewed by the Judicial Conference, but it limits further judicial review. So once the decision is made, it's made. But nothing in this section, however, even purports to prevent litigants from seeking prospective relief that would restrain the council from issuing orders in the future. Now, in March 2024, her argument, before any investigation, the chief judge, called Kimberly Moore of the Federal Circuit, told Pauline Newman that she had been removed as an active judge and she could retire or she could go to senior status. Judge Moore, the chief judge, and the Judicial Council of the Federal Circuit then issued a series of administrative orders that prohibit her from hearing or participating in any cases at all. These orders are ultra-virus. They're unlawful. They're unconstitutional, she says. She has challenged them, and sought to enjoin them so that this doesn't happen to other senior judges. The D.C. Circuit, however, cited a 2001 decision of the court and said there's a bar on judicial review, and she can only make facial claims, but the other courts have no jurisdiction to consider any of this. And so they're going to the Supreme Court and they're asking, does this bar on judicial review violate the Constitution? And removing her and eliminating, depriving her, is other higher level courts actually stripped of jurisdiction based on the statutes cited there? And so, interesting case. Let's take a look at what some of her arguments are. You can see she wrote a big appeal to the Supreme Court of the United States. We love our senior citizens here. Says this petition presents questions concerning crucial constitutional and statutory aspects of lifetime tenure and judicial independence, especially the availability of judicial review. These affect the very independence of the Article 3 courts. And if you just get a little too old, can some other judge just nuke you from the panel? The D.C. Circuit Court of Appeals says, yeah, we can't hear any of this. This is the removal of a judge who is famous from dissenting from her colleagues by those same colleagues, okay, like they're mad at her. How dare you continually dissent and make us look like idiots? Every judge who gets crosswise with her chief judge or her colleagues must now worry about whether they'll be removed as well. So she has continued to speak and write before the legal community. No finding of disability has been made. She voluntarily underwent and passed 3 expert evaluations of her mental fitness and was reported as having the mental ability of someone's decades younger. She has now been suspended longer than any federal judge in history. The length of the suspension and the intention to keep her off the bench are problematic. And now we are going up to you, Supreme Court, saying the Disability Act doesn't approve any of this. And the case law of the D.C. Circuit, I wonder if she wrote this. Interesting. Saying, but the lower courts are bound by the holding of the higher court precedent. And they go through some opinions. And let's get into the meat and potatoes here. For the past 3 years, Chief Judge Kimberly Moore, acting as the complainant and leading to the administrative process, has sought to remove Pauline. Chief Judge Moore has acted on the pretense that Judge Newman is physically and mentally unfit. But she's great. She's 98. She's got the brain of a 78-year-old, which is amazing. Even though this court only 2 terms ago announced a ruling that reversed these other things, Judge Newman resisted her campaign of intimidation. And let's take a look at Judge Kimberly Moore. Who is this judge? Judge Kimberly Moore. And by the way, this lady was appointed by Reagan. And Kimberly Moore, let's take a look at her. This is a Bush appointee. She's age 57. She went to Georgetown. This is the judge. It's judge versus judge today on this little Fun Friday excursion. Says here, this is a George Bush judge right here. Kimberly Moore, U.S. Circuit Judge for the Federal Circuit. George Bush appointed her. And interesting. Oh, this is curious. Her husband is a law partner at Latham & Watkins, which is one of those hack law firms that represents Democrats. So Judge Pauline Newman says that all these laws are invalid. And here are some of the proceedings that have occurred. On December 15, 2022, Judge Newman authored one of her excellent dissents in a decision. This court later adopted much of her reasoning when it reversed. The Supreme Court accepted her conclusion and overrode Kimberly. Some 2 months after Judge Newman wrote that dissent, Chief Moore removed her from normal panel assignments. Dang, that looks like retaliation. Then the next month, the Judicial Council ordered, yep, she's too old. Sorry, you can't hear any more cases. And the order relied on personal knowledge. Although none of them had initiated a complaint, Judge Moore, Kimberly, claimed that other, quote, judges and staff had brought concerns to her about something going on. The order also referred to the statements that Judge Newman had made during deliberations when no one other than the other judges were in the room, and saying people are expressing her concerns. Because the investigation was initiated by the chief judge and based on accusations leveled at her, Judge Newman asked the chief judge and others to transfer the investigation to a different circuit, saying, I know you hate me, so you can't investigate me. Have other people do it. Before the investigation even began, the chief judge removed her from the normal panel assignments. That was improper. The Disability Act doesn't allow you to do that. When Judge Newman emailed the chief judge and asked her to reconsider her exclusion, Moore rebuked the judge and replied to the email via an email list named all judges. So like puts her on blast to the entire panel. Because that list included everybody, the use of the email was also misconduct. The special committee ordered her to submit to neurological and neurophysiological testing by doctors chosen by the committee. The committee also ordered her to provide her hospital records, medical, psychiatric, psychological, and other health professional records. Newman submitted these expert reports. She did hours of testing, and her cognitive abilities are perfectly intact. But the committee rejected those expert reports and declared her guilty of misconduct for refusing to cooperate. It recommended that Judge Newman not be permitted to hear any case, period. And she was removed. Then on September 6, 2024, 14 days before the expiration of the suspension order, they suspended her again for another year. Now, the upshot here is that she has been barred from any functions since 2023, the date which she issued her last opinion that embarrassed all the other judges. And so we've had a bunch of proceedings, lots of details on this. Let's fast forward and see what they argue is the basis for accepting this petition. They say the court should accept this. It's judicial lifetime tenure, and she's fine. She's like a spry 78-year-old judge, no problem. This court has also construed statutes that prohibit judicial review. Some of those can be unconstitutional, and so you should do that here. And Judge Newman has raised a host of constitutional challenges, and you should hear this claim. Supreme Court of the United States. Very technical decision here, or argument here. At the very least, grant the petition, vacate the underlying decision, and stop saying you can strip jurisdiction to hear these claims. The courts of appeals should be able to do that. And let's continue on. The chief judge is using this act because she doesn't want her to serve on the panel. These are heavy-handed tactics. You can't have one judge just say, I don't like you and you're too old, so get out of here. Other judges are watching what's happening, and they're wondering if a similar fate will befall them. Well, some judges actually should be removed under these reasons. Like, for example, the one judge we're thinking of is Roy C. Lamberth, who I think falls asleep and drools on himself on the bench. And I've been in front of judges, by the way, who are just comatose on the bench. You're like, judge. Like somebody's the clerk is poking them with a stick. All this needs to be nipped in the bud before any more damage is done to the constitutional limitations on judicial appointments. Her colleagues have thus far succeeded in silencing her. She was a dissenting voice, and her effective removal from the bench has had a dramatic effect on the number of dissents issued here. One recent study concluded that since she was removed, the rate of dissent in the federal circuit has dropped from 12% to 4%. Losing out on her dissent is not good. And attacks on the independence of the judiciary are coming from both the left and the right. And so for these reasons, we need you, Supreme Court, to step in, issue a strong statement in support of judicial independence, respectfully submitted by the new Civil Liberties Alliance up to the Supreme Court of the United States. And of course, we'll see what they do about it. The case has not been docketed yet. Reagan nominated Newman to the newly created federal circuit in '84. It hears appeals on specialty topics, and she's known as the Great Dissenter. But she's been on the sideline for a long period of time, and her colleagues all booted her off. So this is going to be an interesting one to watch. A little bit different there. But shout out to our senior citizens. We appreciate what they bring, and hopefully Supreme Court can settle this for us once and for all and determine whether she shall remain in her judicial position. Sounds like she wants to be there until the end. So we'll see what happens with this one. Thanks for joining us as we do. All right. So friends, a little bit of a different story there today, but a little curious there. Now, the other thing we were keeping our eye on this morning, which just went live, is this one right now. So we've got, let's hang out here for a little bit. I've got an ultrasound, so I can't hang out too long on this one, But let's check in what's happening here. Let me rewind this because it looks like this just started like a minute ago. So it's not going to be perfectly live, but pretty dang close. All right, so here we go. Out in Georgia, we've got Nathan Wade.
I want to recognize Mr. Nathan Wade has joined us. Thank you for being here, Mr. Wade. You're joined by your counsel, Mr. Evans. And then, Mr. Barnes, are you serving as counsel? Are you hanging out? What's your...
I'm hanging out, but I'll say that I'm serving as co-counsel in which case I won't say.
Would Mr. Wade say that you're serving as co-counsel as well, or is that... So I do want to thank you for being here today. A couple of things before we get started, and then we'll swear you. I don't know if you've had a chance to view any of the other proceedings. We've been charged by a Senate resolution essentially to look into really a couple things now, but as it relates to the Trump election interference case. We've taken testimony from a number of folks actually, not just folks you work directly with on the case, but people, legal experts from around the state. And that's going to be the scope of what we're going to ask you about today. And the goal for us is to see if there's any steps that we need to take to reinsure public confidence in the justice system. Chairman Cowsert brought, what did you write, Chairman, 5 separate pieces of legislation so far? 5 pieces of legislation. I think you passed 3 of them out of the Senate. So that's really the goal of what we're trying to do here today. To the extent that you want to discuss anything with your counsel, obviously you're more than welcome to do that. I do have a mic control here, just like we did this morning for Mr. DeSantis. If I will, as I see you two talking privately, I'll just mute the mic so nothing gets picked up by the media. And so if you hear me say you're muted, that's what I mean, and then I'll unmute. If you want to ask me to do that, I'd be happy to do that. But I'll try to just kind of toggle that as I see you guys discussing things privately. I'll open up with a line of questioning, maybe take a break depending on how long we go. Leader Jones has the option to do so as well. And then Chairman Cowsert had asked some questions previously, and obviously that would be his discretion as well. Did you have any questions or anything before we get started?
I don't have any questions, but I do have an opening statement I'd like to read into the record.
Sure.
Good afternoon. My name is Nathan J. Wade. I am here on my own volition after accepting service of a subpoena from this committee. I'm a lawyer in good standing with the State Bar of Georgia. I served as a special assistant district attorney for the Office of the District Attorney of Fulton County beginning in 2021. Before accepting that appointment, I worked as a prosecutor, ran a private law firm, and served as a municipal court judge for over a decade. For my appointment as special prosecutor, I swore an oath to follow the law. I took the oath with solemn pride and responsibility. I did not accept the position to financially reward or benefit anyone, namely District Attorney Fani Willis. My team and I investigated the state of Georgia versus Trump et al. For approximately 2 years or more. The investigation was not politically motivated or influenced. Rather, it was an independent investigation based on facts, interviews, evidence, and the rule of law. I was not directed, ordered, asked, coerced, pressured, or importuned to bring any charges in that case. We simply went wherever the evidence led us. No one at the White House counsel's office, the Department of Justice, or the January 6th committee directed, ordered, asked, coerced, or importuned, or pressured me to do anything in that case.
Yeah, but they worked with you.
I did not violate a single rule of professional responsibility in the Trump case. I did nothing to compromise the integrity of that investigation. After a thorough and independent investigation, we presented our evidence to a special purpose grand jury. In August of 2023, the grand jury returned indictments against 19 people, 4 of which entered pleas of guilty, and rightfully so. In January of 2024, a co-defendant moved to disqualify D.A. Willis and myself from that case. The court held a hearing during which I testified, was cross-examined by each defendant's attorney, and the link to that public testimony will be made available by counsel if anyone needs it. On March the 15th of 2024, the court denied the motion to disqualify. In that order, the court allowed the Trump case to continue only if DA Willis's office resigned or if I resigned. Later that day, I voluntarily resigned. Since then, I have had minimum contact with the Fulton County District Attorney's Office.
What about Fani,
and I have
though?
had no access to documents or evidence kept there. Based on your assertions to my counsel, the committee agreed to limit my testimony to an hour. The committee also agreed not to ask about any personal relationships or any pending or current investigations and prosecutions.
What?
I request that we honor that agreement, and my counsel will object if we do not.
Don't ask me about Fani.
Please remember that my knowledge about many topics is limited because I have not worked or been contracted at the District Attorney's Office of Fulton County since I resigned in March of 2024. Also, many of the events happened years ago, so I may not remember specifics. Further,
Not
I
that
am
long
bound by
ago, we
attorney-client
remember.
privilege, confidentiality agreements with the Fulton County, grand jury secrecy rules, and Georgia Rules of Professional Conduct 1.6a, which requires me to maintain in confidence all information gained in professional relationships.
You know how this is going to go.
I'm here to cooperate. I will answer questions to the best of my ability, but within the confines of professional and ethical responsibilities. In that light, please allow me to further read into the record this notice and general reminder that I've received from the Fulton County District Attorney's Office
From my
regarding
girlfriend.
my position.
From my lover.
Says, Dear Mr. Wade, I write to you in my official capacity as District Attorney for the Atlanta Judicial Circuit and on behalf of my office regarding a recent subpoena that you received from Senator Bill Cowsert and Lieutenant Governor Burt Jones requesting your testimony before the Georgia Senate Special Committee on Investigations. Related to your former contract or employment as a special prosecutor with the Fulton County District Attorney's Office. The subpoena does not provide any indications of what matters or information your testimony is expected to involve, but given the focus of your work as special prosecutor, I expect that your testimony will relate somehow to our office's pursuit of accountability for the unlawful attempts to overturn the 2020 presidential election in the state of Georgia.
Fani just scolded him right
To
there.
make clear my official position as district attorney, I write to remind you of your continuing obligation not to disclose any confidential information related to this office's criminal investigations, including information that is protected from disclosure by grand jury secrecy rules or applicable legal privileges held by this office. To that end, this letter serves as formal notice that the Fulton County District Attorney's Office is asserting all applicable legal protections and privileges over information you have obtained as a contractor of this office. This includes knowledge of key evidence, confidential attorney communications, discussions of legal theories
Napa
and
Valley.
analysis, prosecutorial recommendations and deliberations,
messages,
as well
indictments,
as
indicting
knowledge
each other.
of the sources, procedures, and techniques employed. Last year, when your testimony was sought by Congressman Jim Jordan of the Judiciary Committee of the House of Representatives, I wrote you a similar letter, which I have attached. This letter serves as the same purpose, and the office asserts the same protections and privileges. In their absent attempts to serve the desires of a few individuals rather than the rights of millions of Georgians, and to discredit the good work of our office to defend the rule of law, members of the committee have recently subpoenaed me as well. My objections to these latest efforts remain the same. I am concerned that questions posed to you by the committee could implicate several significant established privileges and confidentiality interests. These include preservations of the secrecy of grand jury proceedings, which is well recognized principle in both federal court and the courts of the state of Georgia. Attempts by the committee to solicit information from you about evidence in the election interference case would run afoul of these fundamental principles. Additionally, questions about the substance of your work in this case would also seek information that is protected
big
by
Fani
the
letter
deliberative
right there.
process privilege, attorney-client privilege, and work product privilege, among others. As Chief Justice John Roberts has observed, it has long been understood that recipients of legislative subpoenas retain common law and constitutional privileges with regard to such information. The site is Trump v. Measures, USA. It is the responsibility of the FCDA and its employees to protect secret grand jury information or information that is privileged, confidential, or sensitive. As former appointed special prosecutor for the office, this is your responsibility as well. Any protected information would belong to the office, not to you personally, and accordingly, you should refer the committee to this office regarding any such information.
Says Fani.
As you are undoubtedly aware, the sharing of non-public privileged information violates Georgia professional ethics rules, including special rules applicable to prosecutors. Such disclosure can prejudice defendants, victims, or witnesses, or affect the overall integrity of the proceedings.
It's been dismissed.
I know that you intend to comply in good faith with all proper legal requests related to your work with the office. Although I'm sorry that you are forced to deal with the ongoing efforts by others to attack the legitimacy of your work, I thank you for your steadfast compliance with the law
and I love you
for your adherence to the claims of privilege laid out in this letter.
And I love you. I'll see you at home.
I believe that the efforts of Senator Coward and Lieutenant Governor Jones and the never-ending investigations into the FCDA by them and by others, such as Congressman Jordan, are a part of a transparent and shameful campaign to use the force of government to harass, silence, and punish those who have been brave enough to stand up to Donald Trump. No true public servant deserves this kind of public harassment for their work.
Is writing this.
As I have previously indicated, I am grateful for your work as a special prosecutor and your commitment to the highest ideals of American democracy. Yours in service, Fani T. Willis, District Attorney, Atlanta
Fanny.
Judicial Circuit.
Her name's Fanny.
Copies of this
Nathan,
letter
you know better than
provided,
anybody what
through
that
counsel
means.
as well.
Thank you, Mr. Wade.
I stand ready to respond.
I'd like to go ahead and swear you in, if that's okay. If you could raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. I do want to clarify, and Mr. Miller, maybe you can weigh in on this. I did not believe we had agreed to a time frame for this testimony. Certainly don't want to be here longer than we need to be, but I do want to just make sure that we're all on the same page before we start with that.
Like nothing. He just burned out 10 minutes.
My knowledge, I'm happy to discuss at our first break, but just for context, our earlier witness was started at about 10:30 and we were finished before noon, so I don't expect
If we go over a little bit, that's fine. I talked to Josh Belfonte about restricting it to an hour, so
okay.
That was my understanding all along.
I certainly think that I'll get through my stuff under an hour, I hope. And then we'll see, maybe we can break and see how much time we think we have left. Mr. Wade, thank you for that opening statement. It kind of gets to a little bit of your background, and so I don't want to belabor that too much. I think some of that's also just kind of been out there in the news cycle over the last couple of years. So given our time restraints, I don't want to spend a ton of time on that. I do want to just get into a couple of things that the committee's talked about over the past couple of months. But first and foremost, if you could walk me through your process of being hired. I understand that there was some taint work that was done, I think, by your firm and then maybe a firm that you have some partners in, and then that kind of transitioned into you working on part of the transition team. If you could just lay that out for us. And then if you could get us all the way through to being appointed as special assistant district attorney, that'd kind of be as far as we want to go with that.
Yeah, well,
sir, you outlined two separate processes. I had nothing to do with doing any taint work with the Fulton County District Attorney's Office. Those contracts were held by two other lawyers. Nothing to do with myself.
Okay.
My appointment to becoming a special prosecutor dealt with my familiarity in terms of being a municipal judge and Ms. Willis being a municipal judge at the same time. We developed a sort of a mentor-mentee relationship.
Yeah, I bet you
over
did.
the course of time.
Yes, you did. That's true.
Great. Walk me through the work that you did on the transition team. I think that you were part of a transition team, as I understand from Ms. Willis's testimony, between her election and her swearing in. If that's accurate, walk me through it. If not, correct the record for me.
So briefly, I was a part of a transition team. I didn't officially participate in all the work that transition team performed. I was continuously a part of an advisory, unofficial advisory committee, if you will, with her.
Okay. And there was, at some point in time, there was a search committee that was formed. Mr. DeSantis mentioned that this morning. DA Willis discussed that as well. There's a search committee that's formed essentially to look into someone to lead the Trump election interference case. Is that correct?
Yes, sir.
And you were part of that transition team. Is that? I'm sorry, you were part of that search committee.
I was.
Is that correct?
I was.
Who else was it? Was that an official committee that had named members, or was it more of an ad hoc committee?
No, it wasn't. I don't really recall the specifics of how it was put together, but I do recall taking part in doing the work. I couldn't tell you who else was all involved, but I know that she was taking advice and counsel from several other sources.
Do you remember approximately when that work began?
I don't. It was after she had won the election, obviously.
Okay. The meetings that you had that you were a part of, do you remember anybody else that was a part of those meetings besides the district attorney?
I don't recall if, I seem to recall that all the meetings had different members, so there was never a set group of people that met in that regard, and so because of that, I'm having a difficult time recalling.
Do you remember any either formal or even casual interviews for candidates that would be a potential special assistant district attorney?
I do.
Could you tell me more about that, please?
Well, Governor Barnes might be able to answer that a lot better than I would. He was one of the individuals who was asked, I wouldn't call it an interview, asked to step into the role.
And he turned that down, as I understand it from previous testimony, due to his ongoing caseload. He had some concerns about the publicity and security concerns that may come along with that case. Do you remember anyone else that the committee either talked to via a formal interview or informally?
Yeah, I recall. I recall Attorney Gabe Banks being asked to step into the role as well.
Officially offered a role, and he turned it down as well?
Yes.
Okay. Was there anyone else that you recall that you talked to either that turned down the role or was never offered the role?
I don't understand the question.
Was there anyone else that the committee approached about the role?
There were other people, other candidates. I do recall DA Willis being very deliberate and careful about whom she selected for the role. There were lots of people who were sort of applying or wanting to do it because they had political agendas one way or the other, and she was astute enough to sniff those things out immediately and disqualify or do away with those particular candidates. But specific people, I don't recall.
Okay. Do you remember approximately when the focus turned to you as a possible candidate?
I don't remember in terms of time, but I can recall because DA Willis either was not satisfied with those who were applying to do it, or those whom she approached to do it had said no. She asked me to do it. Initially, I said no. I had no desire. Now, had I, in hindsight, I probably would have gone and had another conversation with Governor Barnes to get some specifics about his concerns, as opposed to going through the deliberative process alone. But I did, and ultimately I accepted the position.
I'm curious why you didn't have a desire. It's a high-profile case. You're an accomplished attorney, doing various work both as a judge and as a lawyer. This seems like something that would be a pretty good opportunity. Do you recall why you didn't have any interest in doing it at that time?
Yeah, I do. I rather enjoyed serving as a municipal court judge. One reason would be I would have to step aside, take a leave of absence from that position. The other reason was my firm at that time was doing very well, and I didn't want to step away from that work. The pay obviously was not very good. I don't think anybody can debate that point.
You got like 700 grand there, my man.
And the subject matter, candidly, just didn't get my attention.
What caused you to change your mind?
Fani seduced him?
After having more discussions with DA Willis and having more discussions with those that I look to for advice and counsel, and I have a love for different areas of law.
And Fani.
And this was that for me, so I did it.
Okay. Do you remember if you remember even the month, that'd be helpful, the month at which you officially started in that role?
I don't.
Okay. You served in that role up until 2024, is that correct?
March.
And it would be best described, I believe that the DA described it this way, is that you were essentially the lead of the team that was working on the election interference case.
Yes, sir.
Okay. I want to ask a couple of questions that have come up, and this is one that you've seen it discussed, I'm sure, as it relates to the billing. There's been some discussion of this block billing, and this is just an example. This is one of the invoices that you submitted.
24 hours, no pee breaks.
I believe that you testified that on occasion you would submit invoices and you would receive questions back from the DA's office. There would be some adjustments to the invoices. Is that correct?
So I don't know if the questions would come from the district attorney's office or they would come from the accounting department within Fulton County. But I would get the question and I would respond to it.
Do you remember was the nature of those questions relative to essentially the tabulation of the invoice, which would make sense for it to come to accounting, or was it more so around your description of work that you have listed on the invoices?
No, I don't recall the nature of the questions.
Okay.
35 G's right there.
It was stated under testimony of the district attorney that was her opinion, or at least her position.
Meetings, 8 hours.
That oftentimes you work more hours than you billed. Would you agree with that assertion?
I would agree with that.
Help me understand kind of how the tracking process worked, given that, and were you on a cap of some sort, I believe, in your contract. There was a maximum total billable dollar amount each month, and you obviously couldn't bill more than that. As it relates to these invoices for 8 hours, would you say that the majority of those were 8 hours? Would you say that some large percentage of them where you went over on time but only billed for 8 hours? I think that you would agree.
Yeah, I worked 10, but I had lunch and I
unusual to
billed
see
8.
kind of that rounded billing. We've looked at it in this committee, other billing from people like Anna Cross that worked on the same case, and this is just one example of one of Ms. Cross's invoices, and they're down to, it looks like, the 10th of the hour. Mm-hmm. So walk me through, essentially, help me understand the block billing, and then I want to get a further understanding, if you could, as to how many days you think you went over. I see on the right-hand side there you did bill for, you kind of have multiple days covered, 12 hours across 2 days, that kind of a thing. So I just want to understand the billing. if you need a more specific question, I'd be happy to ask it more specifically, but I'd just like to understand your perspective as you've heard the commentary around the billing practices here.
Yeah, so it's simple. If you take a look at the bottom of this invoice, this invoice specifically says submitted the 31st day of August 2022. Look right above that line. It says, due to billing restrictions, this invoice has been significantly truncated, which means that I was not allowed to bill over X amount of hours. That does not mean that I could complete the task. As a matter of fact, I can tell you for a fact, I could not complete any task in the amount of time that I was allowed to bill. So the way that you see those bills, each and every one of those bills has been truncated.
I'll go back to this one just because it's probably easier for us all to read.
You worked way more than he billed.
What do you mean by that when you say that each and every one of them is truncated? Do you mean essentially the total is truncated, or do you mean each entry is truncated?
Each entry. So the first entry there, you see 4.3. Now that's in 2023, and I don't remember what that was even about, candidly. But I can tell you, I can tell you.
That's why you have more details in your
8
records.
Hours, it probably took me 16 to do it.
Okay, so they're fraudulent, really, reports.
Okay, so on 4/13, you're working more than 8 hours that day. 4/4, I'm sorry, 4/3, 4/4. Then the 3-day span.
So sorry to interrupt.
No, you're okay. Go ahead.
If you look at the top portion of that billing invoice, where it says description in the blue, right next to the word description is date completed. Mm-hmm. So the dates that you're seeing are the dates that the task was completed. That is not the date that the task begun. So if you see 8 hours, and there you see 8 hours billed, it was completed on 4/3.
Okay, so you had a meeting?
started that task 2 days prior.
So that first one, there's a meeting with team.
Yeah, look at the
research.
description.
So obviously, a meeting with the team is a day. I would assume. You're not, are you saying that you're having multiple days of?
Listen.
I know you don't know the
Listen.
specific. I'm just saying, let's just pick that one out as an example.
That's great. That's a great example.
Yeah.
I will tell you this. That team and I probably met in one day, probably 6 times in one day. And that's a small frame. We were constantly meeting because we had a lot of evidence and a lot of work to do.
No, you backfilled. You needed to reach 35,000, and you made it up going backwards.
Because for the most part, you, and I believe you testified to this, you more or less, you were going into an office. You weren't working from a Cobb County, Marietta office. You were working out of some office. I know we won't disclose the location, but there was an office where you were going to work where the rest of the team was working out of.
Absolutely.
Okay. Great. One of the things that the committee's discussed is the accounting here indicates that not all of your bills, but some of your bills were paid out of county forfeiture funds. We've taken testimony in this committee around the use of forfeiture funds. Did you have any knowledge that you were being paid out of forfeiture funds?
I don't even know what forfeiture funds are, sir.
Okay. So forfeiture funds there's a split, as I understand it, where essentially criminals have their property seized, that property is sold, that a percentage of that money goes to a sheriff's office, the bulk actually of that money goes to a sheriff's office. Was it 10%, Mr. Chairman? Flows down to the DA's office. It was, there's some examples here where you're paid out of, out of Fund 100, which is the general fund, and then some that was the forfeiture funds. I didn't know if you were a part of any conversation around different sources of funds, or if you were just sending an invoice and a check came in whenever it came in, and obviously you're not reviewing that check probably to see a fund number on it.
So first and foremost, I have no knowledge of what this document is. I've never seen it. Secondly, once I submit an invoice, if there's not a question about the invoice, I expect payment. Now, albeit when I received the payment, it was most of the time 2 or 3 months later. So I have no clue where the funds came from, what fund was used. I would.
Do you recall one thing that we received testimony on from somebody who works with PAC, I believe, was that one of the limitations that he referenced as it relates to forfeiture funds is you're not supposed to be able to pay anyone more than the prevailing rate of a county employee. And that's about $75 or $80 an hour in that ballpark for the district attorney's office hourly rate for a county employee. Obviously, your contractor rate was more than that. Was there any conversation that you recall about a need to adjust a rate because you were being paid out of forfeiture funds?
Never.
Okay.
Now, I have a need to adjust my rate. Obviously, I'd like to be paid at my normal hourly rate, not the pennies that I was paid, but never.
Pennies.
Okay. You testified, I believe, to Mr. Jordan's committee. Is that correct? Congressman Jordan's.
Yes.
And there was some testimony there relative to the start of the date of the search committee. And we've kind of gone around it on this a couple of times, but I do just want to understand it because I think that your testimony seems to indicate that those conversations were taking place.
Sorry, what are we looking at here?
This is a
transcript from the depot
section of the. I guess it was a deposition before Mr. Jordan's committee. Back in 2024, I believe, was the date of that. And really, what I wanted to get to was here.
I don't know if you signed it.
No.
You want me to pull up the full document? I can pull the full document if that's easier. I just pulled a screenshot here. But you were asked, and so the search committee, you said that began when DA Willis took office on January 1st, 2021. Is that correct? Yes. And there was outreach to you to be part of the search committee prior to January 1, 2021. Absolutely. When did that start? Sometime after the election, but prior to her taking office. Now, you told us today that it was sometime after the election. So that's consistent. Is it your recollection that it was also prior to her taking office that the search committee?
So I'm going to need some context here because, and I don't know if anyone has shared this with you, she had actually formed several search committees. There were committees to fill her office staff. Are you referring to that?
No, and I'll pull up the context for you here. It's going to be a little bit harder for me to do it, but let me just try to get this over on the screen here.
Just kind of stall it up. What is that document? I don't recognize it. What's the full context? Burn time.
I'm going to try to. This top part actually is you talking about the interesting legal issues with the case and kind of what we just covered. And so the search committee, you said that DA, this is what I just read, you said that DA Willis took office on January 1st, is that correct? Yes. And was there outreach to you to be part of the search committee prior to January 1st? Let's go up to see what search committee we're talking about. So January 1st, I was part of the search committee for the newly elected district attorney, and we were tasked with trying to identify someone who would serve as lead counsel on the election interference case. The goal or trick was to make certain that the individual selected was one who had no axe to grind, if you will, which you just said the same thing here. 3 to 5 candidates, you said the same thing here. You referenced Mr. Barnes, so we cover all of that. So we're in the context here of the search committee for someone to lead the special, the Trump election interference case. And so you talk about people turning it down. Governor Barnes turns it down. You referenced the same thing you just did. You didn't give enough credence to his warnings. And so the search committee that you said began when DA Willis took office on January 1st, is that correct? Yes. And there was outreach to you to be part of the search committee prior to January 1st, 2021. Absolutely. And when did it start? Sometime after the election, but prior to her taking office. Okay, so between the election, and you're referring to November 2020 election, is that correct? Yes, ma'am. So when you had the conversation with individuals, you said on multiple occasions, you said no, and turned their positions down. Who were those conversations with? And so I want to go back up to this, and the question I want to get back to is you testified today that you had, it was sometime after the election that you were part of the search committee for the election interference case, you mentioned here as well that that was prior to her taking office. Is that still what your recollection is?
So, and I think she's answered this for you. You can't form a committee before an actual act has occurred. Respectfully, I just don't think that what you're driving at is possible.
Which act did it occur? Because the indictment states that the conspiracy started in November of 2020. The Trump electors met at the Capitol in December of 2020, which that was in the time period between the election and her taking office on January 1st. Obviously, the electors being here was news. I think most people knew that had happened. Certainly was controversial. So the phone call that happened on January 2nd obviously happened after she was sworn in, but the actual reason that a lot of these people were indicted did indeed happen before she took office.
Are you telling me that, or what are we? What
well, I want to establish those facts. I would ask if you would disagree with any of those facts, and then given that, because your assertion essentially was that nothing had happened until after she was sworn in, and I would actually respectfully say that according to the indictment, it was actually the assertion of the indictment that things did begin before she was sworn in.
Okay.
So did the conversation happen relative to a search committee before she took office?
I don't recall.
You don't? I'm sorry?
I don't recall.
Don't recall. Okay. I'll try to get back to this view here. Thanks for indulging me on that.
Yes, sir.
Yeah, were they already in cahoots before she officially even took office?
One last slide here. I've got to do this. This slide's from a couple pages later in the Jordan testimony. Did you have any conversations with anyone besides DA Willis regarding the special prosecutor role and Governor Barnes, I'll say, referencing what we've talked about? I did, and I'm trying to recall if that was, and there's a name that we don't know. He's the individual I had the conversation with prior to my being appointed, if you will, a special prosecutor. He worked at the DA's office. Do you recall who that individual is that is referenced in the redacted section?
I don't.
And it says, okay, so you spoke with this individual prior to DA Willis taking office, and you said I did. Does that help jog your memory at all as to conversations that may have taken place before she took office?
No. It doesn't.
Okay. This is a letter. I'll zoom in on this one as well so we can see it better.
Benny Thompson.
It was sent from Ms. Willis to, I believe, Congressman Benny Thompson, who's chairman of the Jan 6 committee. Have you
illegal Jan 6
seen this
committee.
letter before?
It's when Fani's pumping him for information. Benny.
It says 2021 on it.
I'm sorry. Is that what I said, or I forget what I said?
Well, no, I'm just
okay.
Going through the process in my mind. It says 2021 on it. I can't remember. I'm searching for you, but
sure.
I can't pull it. I can't get.
Just
to
read it.
So this says, please accept this letter as an official request from me to access to records that may be relevant to our criminal investigation. Those records include, but are not limited to, the recordings and transcripts of witnesses, interviews and depositions, electronic and print records of communications, and records of travel. Do you recall there being conversations within the office relative to asking the Jan 6 committee for help relative to any of the things that I just read off that list there?
I don't recall.
Brains fried.
And that, you're right, that was December of 2021. This here, I'll zoom in so we can see this better. Bottom, this is an invoice from 5 months later for a team meeting. Looks like a colon there. Conf with Jan 6 research and legal issues to prep what I assume is a shorthand there for interview. Do you remember a conference call that you had with the January 6th committee in April of 2022?
I do not.
Okay.
Now, certainly I'm not saying that it didn't happen. I'm just saying I don't remember the call.
You don't remember a call with Liz Cheney and Benny
Mr. Wade,
Thompson?
can you repeat that?
Sure. I said certainly I'm not implying that it didn't happen. What I'm saying is I don't remember the call.
Sure. Do you remember any calls that you had with the Jan
No.
6 committee?
I don't.
Do you remember any meetings you had with the Jan 6 committee?
I don't.
No.
Okay. What was the role of the Jan 6 committee as you understand it?
I don't recall.
I'm not asking you to recall. I'm asking you what you believe the role of the committee to
You're asking me what was their role as it relates to
just generally.
my
No,
Do
sir,
you
sorry.
remember them at all?
I'll refine the question as it refers to their existence.
Well, I didn't work with the January 6th committee. So
Yes, you did. You built
whatever
it.
Their role as defined by their
Says right here.
Organizers or statute.
Team meeting conference call with Jan
independent of
6
anything that
research,
I would
legal
have
and
ever done.
prep.
So I don't want to sit and try and.
You spent 24
define
hours doing
what
it
they
there.
were charged with doing because I had nothing to do with it.
Okay.
Yeah, it's on the screen there, dude. What are you talking about? It's right there. Team meeting, January 6th committee, 24
I'll
hours.
scroll up on this one here a little.
You
so
got
can see it
paid
higher. The camera's
$6,000
blocking
for that meeting. You can't remember a
It's your-
$6,000
you're
meeting?
dug down. It's just it's the actual camera. There's
Hammer
a
him.
entry here from about 10 days later. I believe it says travel. Look over here. Travel out of state, interview, and research. Do you recall
No.
specifically what that travel was?
I have no clue.
Yeah, no, of
that's
course you don't.
2022.
Yeah, it was a long time ago.
Not really.
Okay.
Ugh, this guy.
I want to show you a Politico article here. Have you seen this article here before? It says Jan 6 committee helped guide early days of Georgia Trump probe.
I've not.
They state there in the subheadline, in the spring of 2022, the committee staff helped Fulton County prosecutors prepare for interviews with key witnesses. Do you recall either you or your staff working with the Jan 6 committee to prepare for interviews with key witnesses?
No.
Okay.
You billed thousands of dollars for it there, Nathan.
In the body of the article, it says that committee staff quietly met with lawyers and agents working for Fulton County District Attorney Fani Willis in mid-April of 2022, just as she prepared to convene a special grand jury investigation. In the previously unreported meeting, the Jan 6 committee aides let the district attorney's team review but not keep a limited set of evidence they had gathered. Do you recall a meeting with the committee where there was access given to evidence that you were able to view but not retain?
I do recall that.
Okay. Can you tell me about that meeting? Do you recall where that meeting was?
That meeting was in Washington, D.C.
Okay, yeah. It's coming back to you there, Nathan, huh?
Do you recall if that was the meeting that is billed for here, now that you're?
I don't.
Okay. Seems to be in the same time frame. That trip happened in April. So obviously it says spring of 2022 here. So that was in Washington, D.C. Who went to D.C. with you on that trip?
I remember an investigator, but I don't recall specifically which investigator went. And I do recall that there were maybe 3 lawyers from the team, but I don't recall specifically who they were.
And that investigator would be from your team as well, one of the 5 to 10 people y'all worked with. So 3 lawyers, maybe 1 investigator.
It's good. They did go.
Who did y'all meet with there? Do you remember?
Liz.
An
Sam.
attorney.
Liz Cheney.
Do you recall who the attorney was working for?
I do not recall her name.
You know it was a female.
Can we mute this for 1 second?
Yes, sir.
Don't say Liz Cheney. That's my legal advice to you.
Oh, good. Okay.
So, point of clarification.
Yes, sir.
Meeting with this lawyer, the young lady, she was not a member of that committee. This was an attorney.
And she was an attorney working for the committee?
I don't know who employed her,
Great.
but that's who we met with.
Great. Meeting random lawyers.
And had
Right.
the conversations.
Was there anyone else besides this attorney and your staff that was at this meeting?
I don't remember anyone else.
Okay. So this lawyer, you said essentially showed you all evidence, not helped, but showed you guys evidence that had been gathered and did not allow you to retain that evidence. Is that correct?
That's correct.
Okay. Do you recall the evidence that she provided to you?
I don't.
Okay.
Getting pumped info from some rando lawyer.
Do you recall what interviews that followed that evidence was relative to?
I don't.
Okay. How long was that meeting? Was it multiple days? Was it one day?
I'm sure if you go back to the billing, it might tell you if that's.
If this is we don't know if this is the entry or not, but if it was, I'm assuming this travel out of state probably has a good chance of being that because there's not too much travel out of state that you billed for. So this would appear to be 3 total days. You billed 16 hours, so it's not 3 full days. Does that help jog your memory on how long that meeting may have been?
Oh, it doesn't. No,
okay.
Sir.
No, of course not. Why would it? It's only your billing records, Nathan.
The article goes on to say, over the next few months, committee staff also had a series of phone calls with Willis's team. They answered the prosecutor's questions and shared insights on matters like Trump's false electors gambit and his efforts to pursue Georgia Secretary of State Brad Raffensperger. Both of those ploys ultimately featured prominently in the criminal charges that Willis brought against Trump and his allies last summer. Do you remember either you or your staff being part of a series of phone calls with the committee staff?
I don't recall that.
Do you recall if you had any further conversations with the female attorney that you met with in D.C.? Were there any other phone calls or meetings with that particular individual?
I did not have any, no.
Okay. Are you aware whether your staff had anyone working on that? When I say your staff, I'll use that loosely, your team that you were leading.
I understand. I'm not sure.
You're not sure if they did. Okay. And you do not know whether there were any phone calls with anyone else from the committee staff. Is that correct?
I don't understand the question.
The article here says the committee staff had a series of phone calls with your team. I just want to just make sure you do not recall whether your team had any further phone calls with any of the other committee staff.
No, sir.
By Jan 6 committee staff.
I don't know that it happened or did or didn't happen. I don't know.
This says the contacts between the committee and Willis's team also helped prepare prosecutors for interviews with key witnesses. Do you agree with that characterization?
I don't.
You do not agree with that characterization?
No.
Okay. All right, I'm going to go on to the next slide here. This says here, Jan 6 Committee Chairman Benny Thompson had previously described, quote, staff-level contacts between his panel and Fulton County prosecutors. Does that help you remember any other staff-level contacts that were not inclusive of that one meeting with the attorney?
No, sir.
Okay. In early April 2022, nearly 2 weeks before the panel staff met with Willis's team, which does seem to then point to that entry that you did have on your billing as being the correct one for that meeting, Thompson told reporters he wasn't aware of how extensive those contacts were, and on Wednesday, Thompson told Politico that he did not know about the in-person visit that spring. So did you ever meet with Benny Thompson?
No.
Representative Benny Thompson?
I never met with him, but it would seem that it makes sense. If he's saying that he wasn't aware, then perhaps the young lady, the attorney that we were talking about, wasn't even affiliated with Mr. Thompson. I can't put that together for you.
Why are you meeting with random people?
Yeah, I think he just said what he wasn't. He says he wasn't aware of how extensive those contacts were, but certainly he says he previously described staff-level contacts, so he was aware. I think what he's saying he's not aware of is how extensive those contacts were. And I'm just trying to get a better understanding of how extensive those contacts were. Goes on to say, in the meeting, members of Willis's team interviewed some of the committee's evidence on Georgia-specific matters, including Trump's efforts to pressure local officials and the fake electors' actions in the state. Do you remember viewing any such evidence with that attorney when you were in D.C.?
No.
I do not recall what we viewed, sir.
Okay.
No. Evidence? No. From the committee?
It says here, committee staff had more calls with the prosecutors over the following months, including discussions of their conversations with witnesses with whom the prosecutors were planning to interview. The calls helped prosecutors prepare for those interviews. One witness they discussed was Pat Cipollone, Trump's final White House counsel, who spoke with the committee investigators just days before the meeting with Willis's team. Do you remember any calls that helped your staff prepare for testimony from Pat Cipollone?
I do not. I'm not certain who the author of this article is, but I'm certain that they would have no firsthand knowledge of what the content of any phone calls were or conversations.
That's why we're asking you there, man.
Witnesses were. We prepared as a team. We prepared ourselves for interviewing those witnesses, utilizing the evidence that was collected and gathered by our investigators and ourselves, our team itself.
Do you recall if your committee deposed Pat Cipollone?
That means yes. He's processing something.
I'm struggling to. I mean, I recall there being some discussion around it. I don't specifically recall whether we interviewed Cipollone or not.
Did you sit in on
Good Lord.
most of the interviews or depositions?
All of them.
All of them. So if there was an interview or deposition with the president's White House counsel, that you would have sat in on that?
I would have.
Do you recall that, if that happened or not?
I don't.
Okay.
No. Just the White House lawyer. You don't remember that.
We'll go to our next slide here. I'll unmute y'all. Or sorry, you're muted.
Yeah, great comment from one old guy.
Y'all good? Okay.
Do you know what day it is? Do you know who the president is? Do you know what your name
White
is?
House stationery. This letter,
this old guy,
Mr. Way, was part of a open records request that was just fulfilled about 2 or 3 weeks ago. America First Legal and Just the News had filed an open records request that was fought in court. I think that before there was a final ruling on that, there was 8,000 pages that were released. Some of those have been made public. This is one of those, just so you know the origin of this. So this is relatively new to the public record, but was voluntarily released by the district attorney's office. Have you seen this letter before from the White House to Mr. Donald Wakeford?
I'm not recalling. I won't say that I've never seen it, but if it's dated 2022 and it came to Mr. Wakeford, I'm certain that I was made aware of it.
We haven't talked to Mr. Wakeford. That's honestly the first time I've seen his name. This would appear that was he on staff with the DA's office, or was he a contractor?
He was on staff.
He's a staff member. Was he part of your team?
Yes.
Okay. Was he one of the 3 attorneys that traveled with you to Washington, D.C. to meet with the attorney?
I don't recall. I do know that he did do some travel. I don't recall specifically which trips Mr. Wakeford
okay.
was on.
This is a 2-page letter. I'll show you the ending of the 2nd page, because what's at least somewhat significant of this, I think, as it relates to the investigation that you were a part of, is where President Biden waived the executive privilege with respect to the testimony of former Trump administration officials before the special purpose grand jury, which would be your grand jury, or the DA's grand jury that you were helping lead, in connection with any inquiries related to the subjects in the prior paragraph. Does this help you recall at least the overall purpose of this letter? Do you recall executive privilege being waived by the Biden White House?
Well, based upon the letter that you've put up there, I mean, obviously it's about executive privilege, so yes.
What?
Do you recall that executive privilege was waived as it related to the White House? President Trump's executive privilege was waived as it related to your investigation?
Yes, sir. The letter says it.
Okay. What witnesses did that give you access to that you would not have otherwise had access to?
I don't recall.
Yeah, that's way too complicated for
Would
him.
Cipollone be one of those?
Yeah, I don't recall which specific witnesses there were.
B.J. Pack could be the U.S. attorney that they call trying to.
Would it be your understanding that B.J. Pack would be someone whose privilege was waived here?
I do recall interviewing B.J. Pack.
Okay.
Wow, memory.
Who else from the Trump administration do you recall interviewing?
I don't recall. Anyone? Name a name.
Yeah, I'm drawing a blank. If you gave me a list of witnesses, I could probably identify.
Mark Meadows?
Mark Meadows.
Interview Mark Meadows?
Yes.
Cipollone, you already said yes to Cipollone?
No,
Well, we're getting pretty close into the substance of the investigation, so I just want to make sure that we're not.
Yeah, I mean, one of these is in a news article.
We're asking about newspaper reports and public documents, that's fine, but if we're asking about what went on in certain conversations.
Do you recall the event of privilege being waived, something that you were waiting on to be able to proceed with interviews of people that you wanted to talk to?
Pursuant to this letter?
Pursuant to, you would not have had access to them because privilege would prevent you from interviewing them. This letter comes and now you have access to them.
Yes.
Okay. Would you describe this as a significant moment in the prosecution that gave you access to those individuals that would help you build your case?
I don't think one piece of evidence is any more significant than any other.
Well, that's dumb.
The evidence is what it is, and I wouldn't weigh any piece heavier than
that's
any
pretty
other
dumb.
piece. So
yeah,
I
like the
wouldn't
murder weapon is
necessarily
pretty
say that
important,
it's
you know.
Significant or not significant. It's just a piece of evidence.
It's my understanding that the purpose of executive privilege essentially is to prevent this kind of thing from happening, where the president would have the ability to adjudicate his duties and would be able to go to his counsel, similar to the way that we're all going to our counsel with privacy, and be able to get honest conversation. It would appear to me, at least, that the waiving of that by President Biden was significant. Do you recall, as it relates to Mr. Wakeford, talking to him about asking for privilege to be waived from the White House?
I don't recall.
Do you know if Mr. Wakeford asked for privilege to be waived from the White House?
Well, now you're getting into processes and procedures on witnesses, so I object to it on that basis. It gets into the deliberative process on whether.
Thank you, Governor. We got the objection.
Well, just I'm entitled to make the record. You don't have to tell me.
I think you've made the objection.
No, I'm entitled to make the record and make it fully.
Let's hear the testimony.
And say what?
I said, let's hear your testimony then.
Well, I resent that.
Governor, your objection is on.
The objection is that it gets to processes and procedures of how the investigation went on. The question is, did Mr. Wakeford ask for and encourage the waiving of the privilege? That gets into a process or procedure of how the investigation was undertaken.
Just ask them.
You can ask him whether, and you got the letter, you can ask him, did he request it?
So, Mr. Wade, do you understand the question that I just asked?
What's the question?
The question is, did you discuss with Mr. Wakeford, or did you request from Mr. Wakeford to seek the waiver of privilege?
I don't recall how it came about.
Okay. This document here was another email to Mr. Wakeford that was part of that open records request that I referenced earlier. Same place we got the White House letter that I just showed you. This is an email from Mr. Wakeford dated March 14th, 2022 to a Miss Lori Baranek, I believe, perhaps is the pronunciation. Does that name ring a bell to you, Lori Baranek?
It does.
Who is Miss Baranek?
She's the person that this letter went to.
What does she do for a living?
I'm not sure.
Looks like
What's
assistant
an
U.S. attorney.
AUSA?
An assistant U.S. attorney.
Okay.
Nice.
And this is Mr. Wakeford asking the assistant U.S. attorney. I wanted to reach out to you, see if it might be possible for a couple of us from FCDAO to come up the road and sit down with you for a few minutes later this week, possibly Thursday. We anticipate that we might have to make a few more TUI requests, and I thought it would be beneficial to have a conversation about that process. Just let me know if there's something we might be able to work out. Either way, we will see you on Monday at 1 Atlantic Center. The number below is my direct line. We've heard testimony before about the TUI requests that you all were working on. Can you just refresh the committee's memory what a TUI request is?
Just getting permission to talk to people.
Okay. And do you recall if you traveled to this meeting with Ms. Baranek?
I don't recall specifically being there, but I can say that if it was a meeting, I was there.
Okay. Do you know what the meeting is here that's referenced Monday at 1 Atlantic Center?
Well, wait just a minute. That gets into a process and deliberation of the investigation. Do you know what the meeting was about?
No, I asked if you remember. Do you remember attending a meeting? I'll clarify that. Do you remember attending a meeting in March at 1 Atlantic Center?
Again, I don't recall specifically attending the meeting, but if the meeting occurred, I was there.
Okay. So she's with the Department of Justice. This is another email from the Department of Justice to Mr. Wakeford. I actually don't see a date on this one here, but the headline here, heading on the second one does show us that page. Show us the date of May 1st, 2022. So just a couple months after the last one. This one here is from Mr. J.
Yeah, we
Macklin.
read this one before.
Do you know who Mr. Macklin is?
I do not.
Okay.
Of course you don't. We're not denying your request, but we're going to continue to work with you.
And it says, we write in response to your April 19, 2022 letters, Civil Chief Lori Baranek requesting the DOJ's authorization to interview 5 individuals in conjunction with the Fulton County District Attorney's Office. And it says, it goes on to list former Attorney General William Barr, Acting Attorney General Jeffrey Rosen, former Acting Deputy Attorney Gerald Donahue, former Assistant Attorney General Stephen Engel, and Inspector General Michael Horowitz. Were those all individuals that you interviewed?
I don't recall.
Do you recall if you interviewed Bill Barr?
I don't recall.
You don't recall Bill?
Is there any individual on that list that you recall interviewing?
I guess what I'm communicating to you is we could have interviewed all, none, or some of them.
And I don't know anything.
I have no independent recollection of any of these people.
Okay.
Oh my gosh. You don't remember Bill Barr, of all people?
This is an email from Michael Hill to a redacted individual here, but appears to be Miss Alexis Hunter. Who's Michael Hill?
He was a former investigator with the Fulton County District Attorney's Office.
Working as part of the team that you were leading?
Yes, sir.
Okay. Was he the investigator that traveled to D.C.?
I don't recall if it was this investigator or some other one.
So he identifies himself as Senior Investigative Officer. Our office is currently engaged in an ongoing investigation. As we discussed, my team and I would like a brief audience with Congressman Thompson related to the affirmation subject matter. Please forward this communication to Mr. Thompson. Email response comes from Mr. Tim Heap, Investigator Hill. He identifies himself as Chief Investigative Counsel for the House of Representatives Select Committee to investigate Jan 6. We've called that the Jan 6 Committee. I understand if you reached out today to some or all members of the Select Committee seeking information about our interaction with 2 particular witnesses. Do you know who Mr. Tim Heap is?
As I recall, Mr. Heap was one of the lawyers that was in communication with us.
One of the lawyers for the Jan 6 Committee?
again, I don't know that he would have been characterized as such, but Mr. Heaphy and this young lady were associates of some sort.
Okay. Did you ever meet with Mr. Heaphy?
Yes.
Okay.
I just want to say something about the process. You don't meet with a committee when you go to D.C. When he's referring to the select committee, there's independent lawyers that they bring in, various people. You don't know, just because it's on somebody's signature line, you don't know what role they're actually playing with it. So there's layers to these things, and there's nobody that just represents the committee.
Okay, he can explain that.
That's a job in itself. These are independent folks that move
All right,
in
so
and out.
friends, I got to wrap. We have an ultrasound for my beautiful wife. She is going to get scanned and all the things. So we got to head out the door. I didn't realize what time it was. But we'll pause here. Apologies for that, but let me drop the link in the chats in case you want to go and check it out. If you want to listen to him continue to say, I don't recall, I don't recall, I don't recall, I don't recall. Dropping that one on YouTube, dropping that over on Locals, and we'll, of course, we'll debrief that. Members, we'll come back tomorrow. We'll get into it. We had some great donos to check in on real quickly, and then your boys got to get out the door. For some reason, I thought the times were a little different, but they're not. But what we've got is some amazing donos, so thank you for being here. Sorry for the abrupt cut on that, but I'm sure you're falling asleep anyways because Nathan can't remember a damn thing. But it's been a beautiful stream. Let's say what's up to these donos, and then your boy is racing out the door here. And, of course, we had Pauline. I'm just getting started, baby. 98 and young. 98 and young. Amazing. Thank you for that, Muffin Rando. Severus, what's going on? Hey, we got this. Says, first, sorry for the bad joke yesterday. I checked that. I looked that one up, and that was the trans model joke, which, you know, I don't know if it's a bad joke. It's just a spicy joke. No apology necessary. More importantly, safe travels to D.C. Severus, you're a membo. Hopefully we can say goodbye in the morning. We'll come back and we'll wrap it up here, and it'll be a great little short Saturday stream just to say our proper goodbyes. Severus, thanks for bringing in some new friends. Hopefully you can join us in the morning. What's it to ya? 3000. Evan Wagler, what's up? Why though is here. Deborah Skinnett and another year older in the house, courtesy of Severus. Thank you, Severus, for the nice dono and for being here. We've got Rhino Poop. Hey, yeah, what's up, Rhino Poop? It has been a long time. Says, long time. Today I'm compelled to state my admiration for you. What? I'm an old Northeast patriot with 400-year-old roots. Oh, wow. Mayflower compact on the dad's side. Amazing. On mom's side, a grateful second-gen legal immigrant. My nom de plume, comic relief and reminder to clean up poop like Cornyn. No one else dissects and explains the complex like you. Serious with a common sense of humor. Man, thank you for that. I wish you, your lovely bride, and baby G the best fortunes and happiness with the move and adventure. Man, thank you so much for that, Rhino Poop. It has been a while. I haven't seen you in the chat. It's great to have you here. Thank you for the very nice dono and the well wishes. And man, I love that. That history is just awesome. Just awesome. So thank you for that. Yeah, we're going to go. We got a doctor's appointment basically all afternoon. I think we got 2 back-to-back, like an hour and an hour. And so that's what we're doing this afternoon. And then we're packing up. We've got some moving pods coming tomorrow. So we'll have a quick stream in the morning. We'll test out the mobile rig together and say our goodbyes. And then we'll call it a day in this location. So this is it, man. Thank you for that, Rhino Poop. Hey, Renee Sargent, have a fun move. Moving is so fun. I love it. Yeah, we're having a great time. Packing boxes. Oh, gosh. It's a lot of fun. Renee, thank you. Jesser Bob, we need to see the quantity of Roland Paper Company paper that was ordered for the election. If Georgia only ordered 1.5 million sheets of ballot paper and 2 million ballots were received, then there is more proof they faked 500,000 ballots. We also need a copy of all the records from Roland to prove that they are not ordering extra and stockpiling for the next election too. From Jesser Bob. It's a good idea. Where'd the paper come from? George Garbanzo. Hello, my friend. Been a while. What's up, George? It has been a while. It's good to see you. I don't always catch the live show, but I catch up always. Thank you for watching. Yeah, even if you're not here live, thank you for checking out the replays. Mark my words, says George. Not only are the Republicans going to maintain the majority, but hopefully they will gain a super majority. Man, I love that positivity right there. Not only is the glass half full there, George, it's like spilling over with optimism. I love it, George. I hope so. I hope you're right. I hope that the Democrats don't win, because if they do, not only are they going to nuke the filibuster if they take the Senate, but they're going to undo basically everything that they possibly can and then impeach everybody. It's going to be a bloodbath. So we're going to keep the energy up. We're going to keep the positivity up. Mike Johnson seems pretty confident about it. And there is a lot to be, thankful for the wins, in particular the border being closed. So, George, thank you for the nice dono, man. We appreciate it. It's good to see you back. Rick D sharing this story. Yeah, Ed Martin, the pardon attorney, now under attack from the D.C. bar, saying that he violated the rules of legal conduct because he's a conservative or he's a right-leaning guy. And, of course, they attack people with whom they disagree. Rick D sent that from an airplane. Brian Bishop, 18 months as a membo, 2 babies, says even Stan and Kyle scream shenanigans at Arizona. Is that a Super Troopers joke? Man, awesome. Thank you, Brian Bishop. Thanks for being a membo for 18 months. That's a long time. We've been through a lot together. Hey, LZ, on this Friday the 13th, you need extra blessings. Therefore, 1, safe journeys to you and yours. Thank you, LZ. May your new home be filled with joy and peace. Amazing. May you have a positive influence on the political scene in D.C. That's the entire goal. It's to, level things up here. May your transition to Eastern time be smooth. May you make many new friends in D.C. May your discernment rise to meet the challenges you will face. And most importantly, may God go with you and keep you while covering all your needs I have failed to mention. Amen to that. LZ, thank you for that beautiful prayer. That was very nice of you. Thank you so much for that. We hopefully will have all of that happen. Thank you, LZ. Hey, what's up, JE in the house? Thank you, JE. Thanks for becoming a supporter. We'll see you tomorrow morning as we wrap things up here. Hopefully the judge will file a civil action discrimination based on age. Well, she's going to the Supreme Court now. So we'll see what SCOTUS has to say about that. Good to see you, former. Dan, in prior years when Maricopa County Recorder's Office was responsible for processing all ballots cast during the early period and early voting, this represented about 91% of the ballots. Now that the Board of Supervisors have changed that process so that the Recorder's Office only processes early voting as in person, which would be about 2.1% of the ballots cast. Good details there from Dan. Thank you, Dan. Elk Plow, we need more of those nice people in handcuffs. To quote Orc Rick, you need to put your hands behind your back and go straight to jail. From Elk Plow. Yeah, there's a lot of talk of that. And, all these people just kind of get away with it. They say there's no intent of any criminality and they're just idiots and buffoons. Rich Borek says, OMG, that hat. Shout out to Tremendous for the hat. Amazing hat. Tremendous. Jesser Bob, I love you put that hat on. Thank you, Jesser Bob. It's Nathan's hot dog. I mean, we can't do it without the hat. Dan, Rob, we love your Nathan's hot dog hat. Thank you, guys. It's perfect. It's perfect for the stream. He can't remember 3 years ago. How did he pass the bar exam and work as an attorney if he can't retain legal information for 3 years? Yeah, because law school's 3 years and you got to pack all that knowledge in there and then go sit for the exam. He can remember. He's just being coy. That was a very long-winded from Fani, which is basically saying, just sit your axe down and keep your mouth shut, which is what she said, I think, almost verbatim yesterday. Dominatrix Fani. Man, things are going to be wild at that household later. Nathan is just plain stupid, says this old guy, which is vastly different from dumb. I don't think he's going to impart anything important in his testimony. Zone Girl, there were other candidates, but they were smart enough to say no. She did away with anyone who might be competition for her job. This old guy says, Nathan, do you recall anything about this case? Do you know how to get back to your office after this meeting today? Do you know what today is? Who the president of the U.S. is? Hello, are you in there? Nathan, pay attention. Pookie's Mob, we're wearing the Nathan hot dog hat. And this old guy says, quit starting your questions with, do you recall? It just sets the stage for no. Just asked him if he enjoyed the trips and the cruises. Hey, Tama Drummer, what's up? 28 months as a membo. Thank you, Tama, for being here. Says, and this is what we paid almost $1 million for, this idiot to prosecute our heroes. Fanny and Nathan's hot dog needs to go to jail. CK Dolores says, love the spirit, love the hat, and Barr's a liar. AG in Pennsylvania started to investigate, but Barr shut him down. That's why they're acting like the 2020 census was wrong. And shout out CK Dolores. Thank you for the dono. We're excited to hit our appointment too. Thank you, CK. Hey, Pookie's Ma, ask him if he knows even who Bill Barr is, which maybe he wouldn't recall. Lou, what's up? 19 months as a membo. Prayers for a perfect test today. Thank you very much, Lou. We appreciate that. Hopefully that is all about to happen. And 29 months, Ivan LaBerge, what's up? Justice is a joke. for rich Americans. Exactly. You can just basically pay your way out of any repercussions, period. And so, friends, sorry I got to jet so quickly. I thought our appointment was a little bit later than it was, or whatever, but we're out the door. So we'll come back. We'll get into our members' comments tomorrow. I see the Veil had a couple of big ones. Carrie B had a couple of big ones. CK Dolores had some big ones on locals. And so we'll come back locals. We'll hit those comments tomorrow morning and get into it. But we'll wrap here on the day. Big thank yous to our mods and meme smiths. We'll come back tomorrow for members only on Saturday to close out the week. Thanks for joining us as we've been here. Shout out to K Bean, to Carrie B. Thank you both for clipping for us and for being here. And my friends, thanks for subscribing and all the things. This is our final show from here. We'll be back next week, but we'll not be here. We'll be kind of on the road and all over the place. But happy Friday. Hopefully your week is closed out strong. We'll come back on Monday. We'll get into it again. Until we do, I hope you're out there getting after it. And you join us when we do return on Monday, or if you're a member tomorrow to close the things out. We'll come back and do it. But in order to do it appropriately, we are going to need to see you right back here so that together with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful Friday and a lovely weekend. We'll see you back here very soon. Until then, be well and bye-bye.
Thanks for watching, my beautiful friends. Now it's that time where the stream must end. You brought the heat with every chatting line. Together we expose corruption. One more time we dove in the truth where the media hides. Lit up the lies with receipts on all sides. The fight isn't over, but we made them sweat. We ain't done yet, no, not just yet. Because together we are watching the watchers. Truth on our side. Watching the watchers. We won't be denied. Watching the watchers. Eyes open wide. Fighting for freedom with nothing to hide. Drop a like and don't forget to share. And bring a friend who's ready to care. Tomorrow's lies are just today's news, but here we see through